Okay, we're ready. Good morning. This is Friday, October 30th, 2015, and this is the Medical Board of California meeting. I want to ask all of us, please turn our cell phones to silent and make sure they are off the table so we can avoid feedback noise. You may notice board members accessing their laptops during the meeting. They're using the laptop solely to access the board meeting materials that are in electronic format. This is an official business meeting of Medical Board of California. As such, disruptions of the board business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press *1. You will hear a tone indicating you are in queue for comment. If you change your mind and do not want to make a comment, please press the #sign. Assistance is available throughout the teleconference meeting. To request a specialist, press *0. Each person will be limited to 3 minutes per agenda item. During agenda item 12, public comments on the items not on the agenda, the board has limited the public comment period for individuals on the teleconference to 20 minutes. In addition, public comment from individuals here in the audience will be also limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Mr. Melendez will be assisting me with the receiving public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking an action on any agenda item. If for some reason I forget to ask for public comment on the agenda item and you wish to speak on that item, please raise your hand and you will be recognized. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give this speaker slip to Ms. Stoof. Ms. Stoof, can you identify yourself? Thank you. I'll do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make a last-minute comment. I want to remind all speakers to please stay on the topic and keep your comments to 3 minutes or less. I would like to call the meeting to the order and ask Ms. Stoof to please call the roll call.
Dr. Bolot?
Present.
Dr. Bishop?
Here.
Dr. Hawkins?
Here.
Dr. Kraus?
Present.
Dr. Levine?
Here.
Dr. Lewis?
Present.
Ms. Pines?
Here.
Ms. Shipsky?
Here.
Ms. Wright?
Here.
Ms. Yaroslavsky?
Present.
Dr. Yip?
Present.
Dr. Ganadev?
Here.
Thank you.
Thank you. I do want to recognize we got a big bunch of students from Midwestern University. Thank you guys for coming. They are supposed to attend one board meeting, and I'm glad that you're here. And I'm sure you're enjoying San Diego. Public comments on items not on the agenda. I have one slip. Genevieve.
Good morning, Geneviève Clavrol. You know, I got a little bit upset this morning. The medical students are taking picture of what's a sign-up sheet, which is a violation of the Bagley Act. And I talked to many of those students, and they kept on doing it because they said they have to show proof to the medical school that they have attended the meeting. You know, that's of concern to me that the medical school will demand a proof of attendance violating the Bagley Act. And even when they were told that it was inappropriate, they continued to do so, which concerned me as future physician. Thank you for your attention.
Thank you. Ms. Webb, you have any comment?
Signing the sheet is voluntary. I would consider that a public document.
Any other public comments from the audience? If not, any comments on the telephone?
Mark, are there any phone callers?
None at this time.
Okay, thank you. Our next agenda item is item 13, regulatory hearing and the manual of model of disciplinary orders and disciplinary guidelines. We got to follow. This is one thing we got to strictly follow what's written here, which says even good morning. My name is Dave Ganadev. I'm the Vice President of the Medical Board of California. I'll be presiding over this meeting. This is the time and place set by the Medical Board to conduct a public hearing to consider changes to Section 1361 of Division 13, Title 16 of the California Code of Regulations as described in the notice published in the California Regulatory Notice Register and sent by mail or electronic mail to those on the board mailing and subscribers list. The current disciplinary guidelines, 11th edition, adopted in 2011, incorporated by references in Section 1361, must be amended to be made consistent with the current law. Additionally, the disciplinary guidelines must be amended to reflect changes that are occurred in the educational and probationary environment since the last update to clarify some conditions of probation and to strengthen consumer protection. Accordingly, Section 1361 must be amended to incorporate by reference the 12th edition of the disciplinary guidelines as amended in 2015. For the record, today's date is October 30, 2015, and this hearing is beginning at 9:15 a.m. We ask that persons who wish to testify please fill out speaker slips available at the table in the back of the room. The purpose of this meeting is to receive oral testimony concerning the regulatory proposals described in the notice. Regulations must comply with 6 legal review standards, which are, number 1, necessity. Is there demonstrated evidence that there is a need for regulation? Number 2, authority. Does the board have legislated authority to adopt the regulation? Number 3, consistency, that the regulation conflict with other regulations or statutes. Number 4, clarity. Can the regulation be easily understood by those affected? Number 5, non-duplication. Does the regulation duplicate other regulations or statutes? Number 6, reference. Which statutes does the regulation implement, interpret, or make specific? Testimony should address only these 6 standards. Before we begin, I would like to briefly describe the procedures that will be followed. The entire hearing will be taped. Those persons testifying will not be sworn in or be cross-examined. All recommendations and objections will be considered by the board members. Responses to all objections or recommendations will be included in the final statement of reasons. The board will maintain a rulemaking file of this proposed regulatory action. Written comments for the regulation being heard today must have been received by 5 p.m. on October 19, 2015. The recording of this hearing, written testimony, and all written comments received by the deadlines is noticed will become part of the rulemaking file. For record, no public comment was received. A completed copy of the rulemaking file will be available for review at the board's office in Sacramento. To ensure fairness that everything is completely entered into the record and to enable everyone to hear those who are giving testimony, we ask that those testifying follow these procedures. Please speak loudly and clearly. First, identify yourself, who you represent. Then please state your position, support or oppose at the beginning of your testimony. Oral testimony will be limited to 5 minutes per person. Please do not repeat testimony already given. Any written comment you have with you today should be summarized orally but should not be read. After our legal counsel's opening statement, I'll call on those persons who want to testify. Ms. Webb, would you please?
We did not receive written comment during the written comment period, but we have received this morning a comment from Bridget Fogarty Graham with the Center for Public Interest Law, and this is relating to condition 23. I'm sorry. Condition 33, where the board has struck out that after a period of non-practice that exceeds 18 months, that a clinical training program would be required before reentry into practice. And instead of that, the physician would be required to take the Federation of State Medical Boards special purpose examination before reentry. And the reason why staff suggested that the clinical training program be struck for this portion is that a quality of care issue that required a clinical training program would have been part of the probationary order, and the physician before coming into practice would have to comply with the physician before coming off of probation would have to comply with the probationary terms. The concern was that it was piling on maybe unnecessarily and without additional benefit of public protection to require a clinical training program if a quality of care matter was not at issue, and that a special purpose examination would be an appropriate way to ensure that the physician was up on the requirements for practice. So the CPIL suggested that the clinical training program remain in as an option at the board's discretion, and the board could amend condition 33 to state that in the event respondent's period of non-practice while on probation exceeds 18 calendar months, respondent shall successfully complete the Federation of State Medical Boards special purpose examination, or at the board's discretion, a clinical training program that meets the criteria of condition 18 of the current version of the board's manual of model disciplinary orders and disciplinary guidelines prior to resuming the practice of medicine. So that is an option. My concern about that is that it may create challenges to how the board uses its discretion to say you get to take the specs exam and you have to go through a full clinical training program, where the expectation with these guidelines is that a quality of care issue, again, would have already been addressed with the requirement for a clinical training program. So
Okay, well,
I leave it to the board's discussion.
yeah, we'll bring
whether
it
to
on
accept
after
it.
we take the other public comments. Thank you, Ms. Webb. I have one other slip here, Bridget Grammy.
Good morning, Bridget Grammy from the Center Center for Public Interest Law. I think Ms. Webb really explained what our concern was, and the most concern for us is just that you would be giving up your discretion in appropriate circumstances to be able to order this. We don't know how much time might have passed if someone that had a quality of care issue would have done a clinical exam or clinical training, and then, at least 18 months have gone by, if not longer. And we just don't want the board to give up the opportunity to send them back to training if that's what is necessary in those circumstances. So we don't object to having the special purpose exam being an option. We just don't want the board to completely give up their discretion. Thank you.
Thank you. Is there any further testimony? On the telephone?
Mark, are there any callers with comment?
No comments on the telephone.
Thank you. So it's open for board discussion. What would you like on the last item Ms. Webb pointed out? Dr. Levy?
Excuse me, I appreciate Ms. Webb's concern. However, I think the board uses its discretion in implementing, imposing disciplinary guidelines. They are not hidebound rules, they're guidelines, and I think CPIL's suggestion makes perfect sense. Adding specs as an option, but maintaining under the appropriate circumstance the ability to say, for this individual under these circumstances, a clinical training program would be appropriate. I see no problem with that.
Dr. Bishop?
I actually had this independently on one of my notes before I'd seen this today, so I agree fully with the CPIL, and it just makes a lot of sense to me not to give up an option that could be very helpful.
Any other discussion? Yeah, I agree with it too, because clinic exams are exams. Some people are good at taking exams, some people are pretty bad at exams. Sometimes clinical training is required, and one of the issues we're struggling with, what do we do with the surgeons who stop operating and then want to restart surgery after a while, which is an issue we were still struggling with, because there are very few programs or almost no programs which allow a surgeon to do additional 6 months or 3 months or a year of training. So that's the thing the board was looking into. Okay, can we have a, yes,
Make a
Ron.
motion.
Go ahead.
Motion to accept the recommended changes to disciplinary guidelines as stated.
Second.
Any further discussion from the board? Any comments from audience?
Deb, I just wanted to make sure
I'm sorry,
that Dr. Lewis, your comments included the amendments made by CPI.
Yes, my comments, my motion includes the amendments discussed regarding the flexibility the board has.
Thank you very much.
Yes, welcome.
Any comments from audience?
I need to make a suggested motion that will allow us to take this further.
Okay.
And so I would suggest a motion where the board adopts the language with the amendment that I proposed and authorizes staff to prepare the modified language for a 15-day public comment period. After that, if no negative comments are received, allow staff to finalize the rulemaking package to present to the Office of Administrative Law, making any non-substantive changes that are required. An example of that would be, page numbers for the table of contents, any, grammatical commas, that type of thing. And so authorize staff to make non-substantive changes to finalize the rulemaking package.
So I'll adopt as my motion that eloquently stated motion by Ms. Webb.
I thought you,
Dr.
I thought
Levine
you
has
were
her
going to
hands up.
repeat it, Ron, but
I just want to be clear, before we vote, are we voting only on this issue or the entire?
entire.
The entire packet.
Then before we vote, I have a question.
Okay.
Clarification.
And I have one more comment before we vote as well.
Okay,
please.
so then let me take only on this, and then we'll take the entire motion in a minute. Can we do that, or?
Okay. First, you can approve only the amended language for option 33 if Dr. Levine or Dr. Bishop
Right.
has a concern about the other package, because we want the motion to be complete about all potential changes that will go forward for a 15-day comment period.
Dr.
So
Levine.
maybe further discussion is in order.
Dr.
Thank you.
Levine.
And this relates to condition 28, supervision of, changing supervision of physician assistants to supervision of physician assistants and advanced practice nurses. And my question is, advanced practice nurses, under the law, does that include, for example, nurse practitioners? Because those two terms are used differently in practice. It would include,
Yes, it would include nurse practitioners, certified nurse anesthetists, and certified nurse midwives. I believe that those are the three.
thank you.
Thank you, Dr. Bishop.
This will point out my true OCD. I'm sorry about this. Under condition 18, you'll notice at the end of that, it says, and specifies that the program shall require the respondent's on-site participation for a minimum of 3 to 5 days as determined by the program. Is not a minimum of 3 days the same as a minimum of 3 to 5 days? It just seems like it's superfluous language that's redundant. If you say it can be a minimum of 3 days, you don't need to have anything else unless you're specifying a maximum. I said it was OCD, so it may not be relevant.
Ms. Webb, maybe you can answer the OCD?
We need a grammarian as well as a parliamentarian.
But I would assume staff will go through this for grammatical non-substantive changes, and they should just note that.
While they're discussing, I think I can explain why it's written like that. Because it used to be that the requirement for PACE was after the initial assessment was that they would do 40 hours. So that was the 3 to 5 days. So it would be, now they've changed that to where they don't require 5 days of everybody. If the individual comes in and they only need 3 days, now they do 3 to 5. I understand what you're saying. It might be a grammatical issue, but maybe we need to just take out at a minimum of 3 and at a maximum of 5, or something. We could put that at an end. I think
Or just leave it a
that was
minimum
the
of
reason
3.
for the 3 to 5. Well, I don't think you want to cap it, so you want to have the 5 in there.
So I would propose an amendment to address Dr. Bishop's concern on condition number 18. The program shall require respondents' on-site participation for a minimum of 3 days to a maximum of 5 days. No, let me think about that.
I missed that. I can't find that in here. I can't find it. Condition 18.
The program shall require respondents' on-site participation for a minimum of 3 days and no more than 5 days as determined by the program for the assessment and clinical education evaluation. So any discussion on that?
Dr. Bishop, does that satisfy your
I am
concern?
delighted.
Just a question, why would you need to cap it?
That's my
Why would you need to put a maximum?
It's a good point. Why do we need a maximum?
We don't. We don't have to. I think that leaving it wide open, though, would have potential to cause concern during the times of settling these cases, and I'm going to look to maybe Ms. Castro. But I think that if we leave it unended, that somebody's going to have a problem with accepting this term and condition if they think that PACE could keep them there for a couple weeks.
Also, remember that PACE can make recommendations that the physician will have to follow in order to get a passing score.
Actually, the better solution may be minimum of 3 days or 40 hours. Why not? That's what basically you want either at least for 3 days or at least for 40 hours. Is that what I'm gathering?
Days is 24 hours.
Well, I mean, it depends upon. For a surgeon, it's 3 days is 50 hours.
So the language used to say, and at a minimum of 40-hour program. I think because we put the 3 in there, that's why we want, because we don't want them to give them only 2 days. That's why we've put the lower level one in there. I think you would want to cap it. Because any recommendations that occur after that, they're going to have to do anyway. So if they say, we need you to do a fellowship, or we need you to do 10 to 20 proctorings, because this is just the assessment for them to then make their decision. It's not the training aspect of it.
Okay, thank you. That's great.
So do we need to amend my original motion to include the statement that it's a minimum of 3 and a maximum of 5? Is that what you're? is that
Yeah,
the
we'll
consensus
include
of
that in
discussion?
the motion after we'll
Yeah.
finish
Okay,
any discussion, and
Okay,
we can
so,
make the motion and call for public comment.
yeah, we have a motion, you amended your motion.
amended it
Correct.
to include that.
Do we have a second?
Yes, second.
Okay, so do we have any further discussion at the board? If not, from the audience? On the telephones?
We do have a phone comment, and before we open our lines, we'd like to encourage our phone participants to mute their webcast. We have Dr. Khadija Lang.
Go ahead.
Good morning. Can you hear me now?
A little louder.
Okay. Good morning. My name is Dr. Khadija Lang. I'm the president of the Golden State Medical Association. There were technical difficulties, so I'm going to put 2 comments into one period. I will respect your 3-minute guideline. First, I wanted to congratulate Ms. Kirschmeyer for the strong work that she has led the medical board to do in moving forward on the demographics evaluation for medical board actions that was commented on and presented yesterday. I think you guys are doing a strong job. We applaud you for moving forward on this and hope it will get great results. Now, with regards to the current motion being discussed, I do have concerns. One of the reasons we requested the demographic study in the first place was because we had concerns that sometimes when people have this type of discretionary control over the future of a physician, they don't have enough knowledge to know how to do it. No disrespect to anybody on the medical board. However, the majority of the board members are not physicians and have never practiced medicine. The people at PACE, I'm sure, are perfectly competent to evaluate a physician and determine if they are safe to return to practice, and that does not necessarily mandate, in my opinion, a 3 to 5 day window. There are many physicians whose licenses have been suspended, revoked, etc., for reasons that have nothing to do with their competency or ability to practice medicine, and it could be a waste of the time in the PACE program area and a waste of the physician's time. And more importantly, in cases where it's not appropriate or needed for the safety of the public, based on what the physician was brought up before the board in the first place for, it's possible that the cost can be prohibitive. A PACE program currently, I believe, is running at a minimum of about $15,000 additional fees that the respondent has to take on their own after having been out of practice for 18 months. So I would like to suggest that you reconsider if this is a mandatory part of an accused final disciplinary package, that if their offense is not something that indicated a lack of clinical knowledge and a lack of ability to properly and safely care for patients, that this is not a mandatory part of their settled decision. I may not be using the correct terminology, but basically what I'm trying to say is that people can interview a physician. Hospitals do it all the time, where they determine with very good accuracy the ability, the knowledge level, and the skills of a physician, and whether they can safely be brought on as a member of that hospital staff.
Dr.
without
Lang,
observing
please
them for
conclude your
5 days.
comments.
I'm sorry?
Please conclude your comments.
Okay, I think that pretty much concludes my comment. I think that it can be an unnecessary hindrance to a physician getting back into practice when they've been out of work for 18 months. Women take off for 2 years to take care of children, and they come back to work without being reassessed. And I don't think if there was no question of competency and ability to safely care for the patients, that should be a mandatory inclusion. Thank you.
Thank you. Any comments on the comment from the board? If not, we're ready for vote. Ms. Toof?
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip? Dr. Gonadev?
Aye. We'll move now on to agenda item 14, petition to promulgate regulations pursuant to Government Code 11340.6 concerning a requirement for a physician on probation to provide patient notification. Ms. Webb, can you please open the discussion on this item?
Yes, thank you. Please turn to item 14 in your board packets. Consumers Union Safe Patient Project has filed a petition with the board pursuant to Government Code Section 11340.6, asking the board to amend its disciplinary guidelines to require as a standard condition of probation the following. 1, that physicians who continue to see patients be required to inform their patients of their probationary status. 2, that patients be notified of the physician's probationary status when the patient contacts the physician's office to make an appointment. 3, that this disclosure be required to be in writing and signed at the time of the patient's appointments by each patient the physician sees while on probation to acknowledge the notice. 4, that this disclosure be posted in the physician's office in a place readily apparent to patients. 5, that the written disclosures described in 3 and 4 above include at least a 1-paragraph description of the offenses that led the board to place the physician on probation. 6, that the written disclosures include a description of any practice restrictions placed on the physician. 7, that the patient be referred for more details to the board online documents related to the physician's probation. 8, that the physician maintain a log of all patients to whom the required oral notification was made. The log should contain the following: 1, patient's name, address, and phone number. 2, patient's medical record number, if available. 3, the full name of the person making the notification. 4, the date notification was made. 5, a copy of the notification given. And 6, a signed attestation by the patient that notification was received. Respondent shall keep this log in a separate file or ledger in chronological order, shall make the log available for immediate inspection and copying on the premises at all times during business hours by the board or its designee, and shall retain the log for the entire term of probation. After discussion and consideration, the board must decide whether to grant or deny the petition. If the board grants the petition, then the proposed regulatory change is subject to the regular rulemaking process. If the board denies the petition, then pursuant to Government Code 11340.7, the board must write a letter to the petitioners indicating why the board has reached its decision on the merits. This letter is also submitted to the Office of Administrative Law for publication in the California Regulatory Notice Register. And with that, I open it up for discussion.
Thank you, Ms. Webb. So we're going to do a little different on this one. This came from the Consumers Union, so I want to take the public comment first, and then I'll take the staff report, and then we'll bring it to the board for discussion. Okay, I got 8 slips, but at minimum 24 minutes. Please stay within 3-minute period. First one is Marian Hollingworth.
Good morning. My name is Marian Hollingsworth, and I'm a member of the Consumers Union Safe Patient Project. I'd like to talk to you about how important it is for a patient to know about a doctor, specifically if that doctor is on probation. I'd also like to talk about trust. The foundation for a good doctor-patient relationship is trust. It's not only trusting the doctor, but also having the trust and confidence that the Medical Board of California is protecting us consumers from any practitioner who could pose a threat. A few years ago, I was sent to a doctor I later found out was put on probation not only for decades of substance abuse and DUIs, but also for going after a patient with a hatchet. I can't tell you how betrayed I felt that not only was this doctor still in practice and that he didn't have to tell me about his record, but that the medical board failed to warn me about him. I was deprived of my own ability to decide, to give full informed consent about being treated by this doctor. I've read through quite a few cases on doctors over the past year or so, and some have had their licenses revoked for sexually assaulting female patients, some of them minors, only to have their licenses reinstated. One of these is a relative of an influential hospital CEO. In any other job, such as teaching or law enforcement, the offender would have to serve time in prison, have to register as a sex offender, and not be able to work in that position ever again. But a doctor? He can not only get his license back, but he doesn't even have to tell his patients he is on probation. Would you women on the board want to go to a doctor who is on probation for sexual assault? Would you men want your wives and daughters to go to someone like this? And wouldn't you be outraged if no one had told you? We consumers feel the same way. You board members have insider knowledge of which specialists to consult, which doctors are the best, so your families can have the best of care. We members of the public don't have access to this insider information. Our only protection is you, the members of the medical board. Now you can say, go on the website, all the information is there, but the fact is most people won't. Breeze is confusing for many folks, especially for those who don't speak English well enough. And if it's too hard to find a doctor, most busy professionals won't take the time to figure it out. The best and most affordable way to deal with this issue is for doctors to be required to tell us they are on probation. Do your jobs as members of the board. Protect us and give us back the right to decide for ourselves which doctors we want. Require doctors to tell us if they are on probation and why. Help us have trust and confidence in our doctors and in you. Thank you.
Thank you. Next one is Ray, I think, Granlica. Wow, your writing is as bad as doctors. Oh, okay, cruel. Okay.
Thank you. My name is Ray Groylick. I'm with Consumers Union. And I love doctors. My husband's life was extended by 12 years by brilliant, skilled doctors. And those are the doctors that the consumers of California should be seeing. I respect the pressures that the profession imposes upon doctors. I don't lack compassion for the For a physician that's struggling, I have no desire to shame them or to deprive them of their ability to make a living. But doctors who are placed on probation aren't placed on probation for minor offenses. Some of these offenses are just egregious. Because of this, there's no way for anyone to adequately judge a safe margin for repeated error when a physician's allowed to continue to practice. And that's why California consumers have to know when we are entrusting our vulnerable children or precious grandchildren or any of our loved ones or ourselves to the care of a physician for treatment, whether he or she has a track record that's questionable in any way. With all due respect, and I mean this sincerely, it's a problem that none of you will ever face, because by virtue of your seat on this board, ironically, you have the inside information. You will never worry about any of your loved ones seeing a physician that's on probation because you know who they all are. But the loved ones of every consumer in California are as precious as yours are. And they all deserve the same protection from you that your loved ones get. Your website says that it's the mission of the board to protect the consumers of California. And that's a responsibility that you took on. It's on you. And we take your responsibility very seriously. So please, earnestly consider the issues of equality when you're thinking about protection when it comes to notification about doctors on probation. Thank you.
Thank you. Next is Michelle Montserrat Ramos.
Good morning, board members. My name is Michelle Montserrat Ramos. Why should doctors be required to tell their patients that they are on probation? Well, many of these doctors on probation are substance abusers. There are doctors on probation that have sexually abused their patients, and others with mental health issues. These are all dangerous issues that all directly impact patient care. Today I'll refer to him as Dr. A. He was in a program for addicts. He began a program of random drug testing. Why was he disciplined? He wrote prescriptions for himself for controlled and highly addictive substances and forged prescriptions for fictitious patients. Many of the prescriptions were written on prescription pads belonging to other doctors. Yes, he stole the prescription pads of other doctors without their knowledge. He engaged in gross negligence for forging prescriptions for controlled medications and other drugs for self-use under the guise of treating legitimate patients. He admitted that a hospital placed him on a leave of absence. His discipline? He was placed on 4 years probation in November 2013. Just 1 month later, Dr. A was caught using a fake penis and bladder during one of his biological fluid tests. When caught taking a dirty test, he was required to provide a hair sample, which tested positive for several controlled substances. He failed probation because he failed to abstain from personal drug use. His discipline for using drugs and trying to game the system with a fake penis and bladder, you, the board, gave him 1 additional year of probation and 100 hours of community service. Dr. A is a repeat offender. His first offenses were more than enough to give his patients notification of his actions while practicing medicine. Then he violates his probation receives a slap on the wrist with no concern for his patients. His patients deserve to know that their doctor had such a severe drug abuse issue that he would steal other doctors' prescription pads to gain his fix and would use a fake penis and bladder to gain a drug test. Now, I know your response is that this information is on your website now, thanks in large part to the anti-diversion and now the implementation of the uniform standards, but you're not taking into account the thousands of consumers you're supposed to be representing that do not have access to your website and that are too sick to search for this information themselves, that cannot afford to maintain internet access. I'm speaking of the 60,000 plus dialysis patients in California. I know these patients well. I spend 3 days a week in a unit with them. Dialysis patients are the most active healthcare consumers. They see more doctors and specialists than the average Californian. They have more procedures and they're
Please
hospitalized
conclude.
more. Believe me, when these dialysis patients, when they're taken from the unit to the ER, they're not checking their cell phone or their tablet to check your website. Please protect these patients. Thank you.
Thank you, Michelle. Next is Genevieve.
Genevieve Clavral. You know, your duty is to protect the patient, not the physician. And I hope that maybe we can find a way where both the patients and the physician who want to take their life back and reform are also protected, you know. So I don't know how to come to that level, but I think something needs to also be done, because I can also put myself in a place of a physician who is really trying to change and have constantly to divulge. So I think it should be a way where it can be done, where the patient is safe, but also it's some protection for the physician who is trying to change. A middle-of-the-road approach.
Thank you, Genevieve. Next one, Lisa McIfford.
Good morning. I'm Lisa McGifford. I'm the director of Consumers Union Safe Patient Project. We have petitioned the board, as you've heard, to require as a condition of probation that physicians inform their patients of their probationary status. For nearly a year, we've raised this issue with the board with no response, and we appreciate the opportunity to talk to you today and look forward to your response. Currently, doctors have to tell their malpractice insurers and their hospitals where they work that they're on probation. Only the patients, who we would argue are the ones that need it the most, are left in the dark. Opponents of this proposal are saying that probation is a minor action in response to minor problems. That is not the case. A probation order is a revocation of a license, and that revocation is set aside for a certain period during which the board monitors the doctors and certain conditions have to be met. Often, these are conditions the board thinks are necessary to protect the public. Many of these physicians are on probation, as you've heard, for serious offenses like sexual misconduct, substance abuse, and repeated acts of gross negligence. While there are other reasons that people are on probation, nearly all the orders we have reviewed indicate repeated problems. The board doesn't take this lightly, putting doctors on probation. They've identified doctors that they feel need to be watched. We have encountered so much misinformation during this petition, filing this petition about why doctors are on probation, that we call on the board staff to provide the board and the public a statistical breakdown of doctors on probation for sexual misconduct, gross negligence, substance abuse, harm to a patient, and repeated disciplinary actions. Our petition sets out the things that doctors are supposed to do, as was read to you, when they notify patients. Most of those items are things that we've seen in probation orders that have been granted or ordered by the board, where you have have required a doctor to tell their patients. And so most of our ideas came from you all. Many people are surprised to hear that doctors on probation even are practicing. We did a poll a number of years ago, and 79% of the respondents thought when a doctor's license is limited, they should be prohibited from seeing patients until their license is in good standing. So we ask you, don't make protecting doctors' reputations a higher priority than ensuring that patients are well informed. We are happy about your outreach program to educate consumers, but this is not a substitute for the petition that we are requesting you to respond to.
Please conclude.
These patients, shouldn't be a substitute for direct notification to patients by the small fraction of practicing physicians who have come to the attention of this board for serious enough acts or digressions from standard of care to place them under years of board monitoring. Thank you very much for your consideration.
Thank you, Lisa. Next one is Julie D'Angelo, Falmouth.
Good morning, Dr. Gunadev, members. Julie D'Angelo, Falmouth from the Center for Public Interest Law. CPIL supports Consumers Union's petition in concept. We support the disclosure of probationary status in a meaningful way. We are not dogmatic about the precise method of disclosure. And we acknowledge that since November of 2004, this board has posted its disciplinary decisions on its website so that a patient, if she knows about the existence of the medical board, if she knows that information exists and is available there, and if she has access to the internet, can access that information. Importantly, physicians on probation have been afforded full procedural due process, and they have either, in the vast majority of cases, agreed to probation or have been ordered to complete some terms of probation by this board. But we have an additional reason for supporting disclosure of probationary status, and it has to do with your probation unit. That unit is monitoring physicians who have come within a whisker of revocation and have been seriously disciplined. And any violations of probation should be detected promptly and should become the subject of a petition to revoke probation so as to remove a dangerous practitioner. In 2004, that unit was staffed by 14 peace officer investigators, sworn staff. Since then, those individuals have been transferred to your investigative staff, and they have been replaced by non-sworn staff lacking the powers of sworn peace officers. In addition, that unit remains under this board's jurisdiction. They did not get transferred to the Department of Consumer Affairs along with the peace officer investigators. So this unit is within your direct authority. There's not a lot of transparency surrounding the probation unit. It was not addressed or described at all in your latest Sunset Review report. But the fact is that your non-sworn probation inspectors have double the caseloads of the peace officers who investigate your disciplinary matters. They have to monitor compliance with all terms and conditions, and you know your orders, there's dozens of them, of approximately 520 probationers at any given time, including almost 3,000 required drug tests per year as of 2011-12. According to your latest Sunset report, 306 drug tests taken by probationers in 2011-12 turned up dirty. Yet your probation unit reported only 33 probation violations to the AG's office, and the AG's office filed only 34 petitions to revoke probation. Those numbers do not compute. If those 306 dirty drug tests were failed by 306 different doctors, then 10 times that number of violations should have been reported to the AG's office, and 10 times that number of petitions to revoke probation should have been filed. Either your probation unit is not detecting violations promptly, or the AG's office is not filing petitions promptly, or it could be an ALJ problem. To me, the failure of a drug test by a doctor on probation who has been ordered to undergo drug testing should be grounds for an immediate cease practice order.
Please conclude.
Thank you. What I'm saying is two things. If the probation violation detection function is not working for whatever reason, patients are at risk, and that argues for you to grant CU's petition to require doctors to notify patients of their probationary status. But the problems in probation should also be addressed by the Enforcement Committee, by staff. I was happy to hear Ms. Delp say yesterday that the probation function is an area of focus. We stand ready to assist Dr. Yip, Ms. Delp, with this issue. Thank you. Thank you.
Thank you, Julie. I will take your comment on drug testing of physicians very seriously, and we will look into that. You're absolutely right. If your numbers are right, it should have been there. So that's what consumer protection is. We don't take them lightly. Next one is Yvonne Cheng.
Good morning, Yvonne Chung with the California Medical Association. We have significant concerns regarding this proposal. We believe that information about licensing statuses are already available on the medical board's website. We would argue that physicians can be disciplined for a wide range of offenses, many of which do not directly pertain to quality of care. These could include, record-keeping errors, failure to pay their taxes, failure to pay child support, having a mental or physical condition that requires a limitation on their license. When a physician is placed on probation with restrictions, this means that the medical board has deemed them safe to practice with these restrictions in place. Probation is not full, unrestricted practice. Employers and hospitals are notified about the licensee status to ensure that these restrictions are properly enforced in the workplace. In addition, requiring a physician to contact patients regarding their probation status sends a mixed message regarding the physician's safety to practice. On the one hand, probation indicates that a physician is safe to practice with these restrictions, but a required disclosure would also imply that physicians are not safe to practice and need to report this to their patients. We believe that the medical board truly believes that if a physician is not safe to practice, they would revoke their license. Mechanisms already exist which allow the medical board to suspend or require the physicians to cease practice if they are found to be a danger to their patients. It should also be noted that many physicians agree to probation as part of a settlement, not because they agree with the board's determination of guilt, but because they lack the financial resources or qualified legal counsel to continue to defend themselves in a full investigation and hearing. If physicians who are currently on probation had known that this potentially would be required of them, many would likely have opted to fully defend themselves rather than agree to probation. We'd also like to add that this requirement could inhibit the board's ability to settle cases, resulting in further strain on your investigative and hearing resources, as well as substantially higher costs to the board. We urge the board not to adopt this proposal and not to move forward with this regulatory process at this time. Thank you.
Thank you, Yvonne. And the last slip I have is Jeffrey Gordon.
Good morning. Before I start, as a former board member, I'd like the privilege of extending my time, although it will not be a long time. I need to be able to emphasize points, and I don't want the restrictions of time limitation.
No, sir. Everybody is 3 minutes.
I am a retired family doctor, having had a solo practice here in San Diego for 35 years. I currently work part-time at a clinic for the homeless, and I am a consultant in bioethics at Sharp Memorial Hospital. I had the great privilege to spend 8 years on the Board of Medical Quality Assurance, starting in 1976, after the passage of AB 1XX as one of Governor Brown's appointees to the Board of Medical Quality Assurance, the predecessor to your California Medical Board. Thus, I speak from extensive, intimate, personal experience of the great responsibilities that you have and that this office gives you on a day-to-day basis. Our board has obviously two important responsibilities. The first is to protect the public, and the second is to supervise the profession. Because I want some more time, I need to recall for you history of which you are unaware of important and relevant past occurrences on this board and the reputation of the California Physicians Licensing Board. In recent history and legislation, this board has given first priority to the consumer to protect the general public. When I was on the board, to ensure this policy, our board was the first in the nation to have a non-physician as president of the board. Secondly, our board was the first in the nation to have a substantial number of non-licensees as members. And for several years while I was on the board, we resigned and took our dues away from the Federation of State Medical Boards because we determined it was captured by the profession and had anti-consumerist attitudes. This changed national health policy and professional medical licensing, and we rejoined the Federation. I'm sure that all of you, as current members, are unaware of this history. It is in this tradition that I come before you today to listen to the people who preceded me and to take seriously the petition to approve and make patient notification a standard part of probationary orders. We all know that the investigation and discipline of physicians demands the greatest attention to the legal due process and the facts of the case, as well as good sense and judgment. In most cases, the record of disciplinary actions over the years reflects physicians are given probations with terms and condition.
Please
Here the
conclude.
goal is- I'm not going to stop. You've got to listen to me. This is a very important issue, and you can't cut me off. This
The
is
board
disrespectful.
Is allowed
I am here
per
as a former
statute
board member.
to have reasonable constraints on public comment so that the
I
business
am
can
not a
be
member of the
conducted.
public. I am a
You
former
are, sir.
board member, and you ought to be respectful.
And we appreciate that, and this is awkward, and I
I will
would
make it more
appreciate
awkward. You have to go
respecting
forward based on the
procedure.
facts. I have given to your secretary a folder in which there are published articles from the University of San Francisco that showed that disciplinary actions against licensed physicians were preceded by inadequate and inappropriate and unprofessional behavior as far back as medical school. These are lifelong problems for which probation is not merely a temporary rehabilitation action.
Doctor,
The public needs to know.
please respect the board's
Secondly, I can
process.
give you
You have 3
cases
minutes. You
where
chose
your
how you
website is
constructed
not
your
adequately
comments.
defending or giving proper
I will have to
information to
cut
the
the
public.
mic if you don't respect the process. Please don't make this any more awkward than it already is.
I will give you a case of a physician that I got disciplined for sexual abuse who is not.
Sir, we got your message. Thank you, we really appreciate it. Can you please conclude?
Doctor, please don't make us ask you to leave.
I find this to be very disrespectful. This is a hugely important that you're being self-protected. When I started on the medical licensing board, the first case of discipline was merely reference to the Business and Professions Code. And when that was changed to include a narrative, the California Medical Association protested.
Peace officers are approaching you so that we can bring order to this proceeding. Thank you.
You have no idea how inappropriate you are.
We appreciate your comments. Thank you.
Any other comments from the audience? Any comments on the telephone?
We do have three
Go ahead.
phone comments. I
Go
would
ahead,
like to remind our phone participants to mute their webcast. First, we have Susan Shinazi.
He probably made a seat so he could get it in the media, right? Something. Oh, I hope the media showed up. I don't know.
Please speak up. We cannot hear you.
From the audience. Any comments on the telephone?
Could you please mute your webcast?
Hello? Can you hear me?
Yes. Yes. Go ahead,
Hi,
please.
this is Susan. I don't know if they're talking to me or not.
Susan, you'll have to mute your webcast because there's a delayed response.
Oh, okay. Okay, can you hear me now?
Yes.
Hi, this is Susan Shanese. I'm with Consumers Union Safe Patient Project. Lisa McGifford is there, and she is going to pass out for me a blog that I wrote titled "Every Patient Must Know If Their Doctor is on Probation to Make an Informed Decision." That's right, making an informed decision includes knowing your physician's background. When the board previously said no to physicians telling patients that they were on probation, the board did so without knowing what the needs were, what the needs of the public you are supposed to be protecting were. The White House, that's right, the Obama administration, has done a recent study entitled "There is a Digital Divide in the United States" that tells us 1 in 4 people do not have internet access at home. The U.S. Census Bureau tells us California population is about 40 million, 38.8. That's a 2014 statistic. That means almost 10 million Californians are without internet service. Your job is to protect these people also. The United Ways of California report in 2015 states 1 in 3 California households do not have a sufficient income to meet their basic cost of living. That is 13 million Californians that cannot meet their basic cost of living. Basic cost of living does not usually include internet service. And even if they have a very cheap cell phone, they are not able to pay for internet service on the cell phone either. And I'm sure there's studies to prove that. Chronic health conditions oftentimes catapult people and people and patients into poverty, or at least very limited income. These patients see the most physicians. These patients, some of these patients have language barriers to the information online. Well, many, since we have over 200 languages spoken in California, and the board is only in English, right? The online free physician lookup is only in English. Many elderly and disabled have lower income problems as well as problems with reading, text, and typing. So it's really ironic that these chronically ill patients, the very patients that see the most physicians, do not have access to their doctor's probation status because this board, the Medical Board of California, decided to function like a concierge medical board instead of serving every patient, every public member equally. Thank you.
Thank you. Next one.
And again, we'd like to remind our phone speakers to mute their webcast. Next is Carol Moss.
Hi, good morning. Can you hear me okay?
Yes, thank you.
Okay, great. My name is Carol Moss. I'm co-founder of Niles Project, and I'm also one of the very dedicated public voices that work with Consumers Union Safe Patient Project, who are dedicated patient safety that we all are looking for. We are asking the medical board today to approve the request of Consumers Union and provide the basic human right we all deserve. I understand what it feels like to serve as a voting member representing 38 million Californians. It's a great honor. I serve as a voting member on the governor-appointed HAI Advisory Committee for the state of California and have served there for 7 years. Your decision to approve this request will be greatly appreciated. Please don't deny us this basic human right of choice. Help us have the trust and confidence in this board by by approving this petition today. Thank you.
Thank you. You have one more?
We have another phone comment. Dr. Khadija Lang.
Go ahead, please.
Good morning once again. I thank all of you for taking our comments on this. I would like to say first and foremost that I appreciate the comments of my colleague from the California Medical Association, which really summarized very well some of the concerns from the physician's point of view. I think that our organizations must also make certain that we advocate for the rights and safety of physicians as well as patients. But with response to the comments by the very passionate members of the public that have come out to speak on this important issue, I think something that needs to be taken into consideration. Two things I want to say, I'll make it brief. Number one, as a physician in private practice, I can say that putting another piece of paper in front of a patient, right now we have to give a new patient coming in and each patient coming in a million different forms that various health plans say, oh, the patient must fill out this form too, and this form too, and this form too. I cannot begin to tell you how many times a patient fills out a form, they check everything, sign their name, and I get in there and ask them, so what is, you said you've never had a surgery before, but what is this scar on your chest here? Oh, that's when they did the such and such operation, but you said no surgeries. So giving a patient a piece of paper and telling them that all of this information, when patients are already overloaded with paperwork that they're required to fill out before they can get in, they came to see a doctor, not papers. Giving them yet one more piece of paper, though you feel that this would be a very much more important piece of paper than all the other papers they've already received, is not necessarily going to have the safety effect that you are expecting, because the patients are tired of filling out papers, and giving them one more piece of paper is not necessarily going to increase their information because they've stopped reading. They're overwhelmed with all the papers that they have to fill out just to see their physician. My other comment, in addition to what the CMA has already stated, is that I think we need to bear in mind that the medical board does have discretion. They do not have to put a physician back out to practice if they feel that physician is in fact a safety risk to the public. And that is what the medical board is supposed to already be doing, only putting back out those physicians that are not a significant safety risk to the public. I think that it's important to also understand that this is an onerous responsibility to put on a physician to try to add that paperwork and keep those logs. It takes away from the time that their staff has to take care of the patients. But the medical board has already pretty much determined that these physicians are safe to be back in practice. And lastly, as the president of an organization
Please
that
conclude,
represents
Dr. Lang.
American physicians, those physicians that opt to practice in medically underserved areas are already underpaid for the work they do, and putting one more onerous thing on there to cause those physicians who do have a license, even if it's on probation, to move to other areas where they can make enough money when they see their patients.
Dr. Lane, please conclude.
I'm sorry?
Please conclude. Your time is up.
Okay, I just think they need to know that that might cause areas that are already having shortages of physicians have even greater shortages of physicians, because that might force physicians to go and practice elsewhere. Thank you.
Thank you. Any other on the phone?
No more phone comments.
Thank you. So the staff checked into this with the other boards, other states, and whatever the investigation they needed to do. So I will have Ms. Kirschmeyer say before we go to the next. After that, I would take, I'll go into informal discussion first before we take a motion, and then we'll go for the motion. So if board is acceptable with that, we'll go that route.
So I did a survey actually with the other boards of the Department of Consumer Affairs, and I believe there's about 38 boards, bureaus, and committees under the Department of Consumer Affairs, and I heard from 26 of them, including both healing arts as well as non-healing arts boards. There's only one board that actually has in their optional terms and conditions, in their disciplinary guidelines, a requirement that they have to post a sign during probation and also have that information on their website. As a physician, if you had it's actually the State Board of Optometry, and if they had a website, that information would also have to be posted on their website. That was the only board that had it. However, although they've had it for 2 to 3 years, they actually have never used this term and condition because they can't, during settlement, nobody has put that in a settlement, and when it's gone to hearing, no administrative law judge has put that into any of their terms and conditions. So although they have it, it has never been used. There's several boards that require during suspension, or weirdly enough, revocation, because if you're revoked, I'm not sure why you'd have an open practice, but during suspension or revocation, they actually have to post a sign. And there were 1, 2, 3, 4, 5, 6, about 6 boards that had that requirement. And then the last group, there were a couple, 1, 2, 3, there were about 3 organizations that had a requirement very similar to ours, to where during certain conditions, they would have to notify their clients or their patients or whatever the case may be. So there were only a few of them where, for example, if there was a condition that they had to, where it impacted therapy or confidentiality of records, then they would have to notify their patients. So for us, that would be like a practice monitor, where you have somebody outside reviewing their terms and conditions, so that confidentiality has now been breached. Those boards had, and like I said, there were only, I think, 4 to 5 of them that had those requirements. So really, there's one board that has this requirement that's being requested of you, and that hasn't been used from that. And again, it's because it's a optional term and condition. I do know that board tried to make it a standard term and condition, and unfortunately, they weren't able to put that into their standard terms and conditions due to the opposition that was raised. For other states, I have the ability to send out a request to other states to find out if they have this. Unfortunately, it's optional for them to reply to me, and so we had 6 boards that had replied, and not a one of them of other state medical boards nationwide. I only heard from 6, and none of them had the requirement. I did talk to the Federation of State Medical Boards, and although they haven't done any research on this, they did say that according to them, they don't believe that there's any board that has this requirement, but I can't verify that because I haven't contacted all of the 50 boards. Like I said, I only heard back from a few of them. So I just wanted to provide that information Dr. Gonadev had requested.
Could I ask for a point of clarification on Ms. Kirchmeyer's remarks, please?
Yeah, please, go
You
ahead.
said that there were approximately 3 sets of circumstances by which this would be, in fact, necessary for the doctor to notify the patient. Could you clarify that, please?
You mean for those boards that they had a term?
No, for the terms that we do.
I'm not talking about anything we do. We have certain terms and conditions, even as pointed out, I believe in the administrative petition, where we do, like right now, if you have to have a third-party chaperone, you have to notify that individual when they come in that you have this term and condition. We have a couple terms and conditions in our disciplinary guidelines right now that we already have to notify patients under certain circumstances. The doctor has to, not us. But.
I just thought it might be beneficial for the community that's present to hear those conditions. That's why I asked the question.
Thank you. So it's on for informal discussion, then we'll take a motion. So free for all. Dr. Hawkins.
Thank you very much. So I want to make a statement that this petition or request, I believe, does have merit. It should be viewed in the way it's presented, and I think the consumer union should be commended for bringing it forward. I believe that irregardless of the outcome, that California consumers will have a better understanding of what the medical board does, and they'll be made aware of the fact that they can get information about their physicians. I'm a recent appointee to the medical board, appointed in March of this year, And I'm convinced, I feel strongly that this medical board understands its primary directive to protect the public. I was one of those physicians who wondered about the medical board several years ago about whether there was bias. Bias does not exist in the medical board. I'm convinced of that because I'm a member and I'm inside the room. I believe strongly that probation does protect the public. The guidelines are set to actually impose standards that requires that the public is protected. Not everybody has committed an egregious crime who gets on probation, but the guidelines are very, very specific, and we do adhere to those guidelines. We've already said that the information is available by going to the website, and we acknowledge that not everybody has access. As I said earlier in my opening remarks, that this dialogue will help more people understand what is available to them and how to get access to the to information about their physicians. I do think that, and this is just to maybe amplify what Dr. Lang said on the phone, is that this is redundant, it's excessive, and I actually think it's punitive. There's a lot of information that's required to be collected of physicians. Those who, once this information is, if we do adopt this this request, and I think finally, I think that, because I'm not sure if anyone else is going to say it, but I think that what happens when you actually require the physician who is on probation for any number of reasons, and the board feels that this probation will protect the public, what you do is you poison the well. You say that, well, this doctor's done something bad, and this gets in the way of that patient-physician relationship, which will be forever changed based on that information. And I'm sure that not everybody will have the same impression of that doctor before and after they understand about that, yet the care would have been the same. Or the care will be modified because the patient, if they decide to stay with the doctor, says, well, what really happened? And on and on and on and on. It will get in the way of patient care, and those are my comments.
Thank you, Dr. Hawkins. Dr. Kraus.
Thank you. I appreciate that the Consumers Union Safe Patient Project has forwarded materials and links to news articles and editorials on this matter. I reviewed them, and I was intrigued to read that many of the media publications referenced this board's rejection of a similar proposal in 2012, prior to my appointment to the board. And in those articles, it was noted that this board is comprised of, in majority, by physicians, by which I infer that some in the media and public may believe that a physician board member is too conflicted to weigh these matters. So before proceeding, I should restate my own conflicts of interest. I am a physician. I derive my income by way of provision of medical and surgical services. I am a trustee of the California Medical Association, from which I receive no compensation. I am a member of the board of the California Ambulatory Surgery Association, from which I receive no compensation. I am an examiner for the American Board of Ophthalmology, from which I receive no compensation. In fulfilling my duties as a member of the Medical Board of California, the state provides $100 for each day of service. So one may conclude that my commitment to consumer protection and my volunteerism is a severe conflict to my own personal interest. I should further reveal that no one from any of the above-named organizations has lobbied me on this matter. I did, however, engage in email exchanges from September 8th through 11th, 2015 with Ms. Marianne O'Sullivan of the Consumers Union Safe Patient Project. In my position on this board, I share the concerns of the Consumers Union. I would like to relate some examples of concern wherein no obligation exists today for present or future patients to be informed of probation by the provider. All of these cases are already part of the public record, and my citations do not violate any rights to privacy. Raymond Azuzada of Los Angeles is on a 3-year probation for possession of cocaine and ecstasy. Dr. Barzak of Riverside is on a 10-year probation. He was arrested in 2013 for driving under the influence in a reckless manner. The vehicle was observed striking the center divider a couple of times, driving up on the sidewalk and almost hitting other cars. When the deputy looked in the respondent's car, he saw bottles of propofol on the driver's side floor, and there was an IV line hooked up to a midazolam bottle with the syringe in place. The respondent appeared to have an unsteady gait. His speech was slow and slurred. He was arrested. An inventory search revealed 4 vials of propofol, 1 vial of ketorolac, 1 vial of midazolam, and 2 McDonald's fast food bags containing dirty needles. Bruce Innes of San Diego is on a 3-year probation for inappropriate sexual actions with a patient. Dr. Kim in Santa Monica is on a 7-year probation for repeated negligent acts in association with the death of a patient in his clinic in 2011. In 2006, a 17-year-old girl died from an infection acquired at a facility in Mountain View. The interesting thing about these cases, all of which are in the public record, is that Raymond Azuzada is a respiratory therapist. Dr. Barzak is an osteopath. Mr. Innes is a physical therapist. Dr. Kim is an acupuncturist. And indeed, there are citations of more than 90 deaths in association with acupuncture. The girl who died from an infection acquired at the facility acquired her infection at a nail salon supervised by the Board of Barbering and Cosmetology. My point is that the public does need to be informed, but this is not just a medical board issue. As Kim noted, the Department of Consumer Affairs has 42 boards and bureaus, 20 of which are health-related. Each board's website is variable in the ability to research the disciplinary actions taken against licensees. I would recommend greater ease and uniformity of access to public information concerning all healthcare providers. Some of the recommendations offered in the Consumers Union's petition may be helpful, but this petition, which may need today to be accepted or rejected in its entirety, may be excessive and may prevent successful conclusions of disciplinary proceedings. My personal recommendation is for continued meetings with all stakeholders to achieve improved public information regarding disciplinary actions, but it should not be taken just by the medical board. It should involve the entire Department of Consumer Affairs, and we do need to remain cognizant that if every physician coming under disciplinary proceedings is going to have these excessive actions taken against him or her in excess to that which is imposed by any healthcare boards, the board may have much greater difficulty in disciplining physicians and having physicians accept probation. So, in conclusion, let's work on it.
Thank you, Dr. Krause. Ms. Shipsky.
Thank you. I want to thank, first of all, the consumers who have come forward, because this is a serious issue. My concern is that I think there's an assumption, and I know that you gave us an article on it that deals with that assumption. Everyone out there doesn't have access to the computer. We are seeing a difficulty, particularly in the older population, who are the high consumers of healthcare, that they either do not have the internet or they don't know how to work it. And so what I would ask as a non-physician is, how do you communicate with people who don't have access to the internet? Because if we don't deal with that on a number of issues, we are really excluding a great deal of the population, and we are assuming, and the other, people who don't have access because they don't have a home computer. There's a variety of reasons why people don't have access to the computer. I do think that Dr. Krause's remarks need to be taken to the Secretary of DCA, because I do think that disclosure should be system-wide, and it shouldn't be just particularly focused on one particular element of licensees. But I would just throw the issue back and say to staff, maybe you can help on this. How do we reach people that can't get to the internet, that don't understand it? I teach in the university level. My students cannot understand the websites, okay? They try to navigate them, but it's difficult because you have to have a basic knowledge to get into the website to understand where to look. I think someone yesterday mentioned, I do think for the average healthcare consumer, the term verify has no meaning for them. It actually reminds me of the nuclear deal that's being done with Iran that we're going to verify, trust and verify. People don't use, that's not common knowledge, that's not common verbiage for healthcare consumers. Check out your doctor. Something very friendly in the terms of what they understand, because they don't quite understand what it means if they go in there, what verifying the licenses. I think we can do better. I don't recall, I know you mentioned this, but I don't recall it because I was on the board in 2012. I don't recall that this issue, we rejected. We did. I was looking at Barbara over there, and I don't remember that we did that. Whether or not we did, the point is we now have to deal with it. So if staff maybe could help, not necessarily answering today, but we've got to grapple with this. So I would hope that we can make a motion that we request that this issue be sent to the Secretary of DCA with Dr. Krause's, I think, suggestions that we look at how do we disclose information on any licensee who has been disciplined, so that the consumer can get that information and so that it is standardized. And the other thing is, how do we deal with people who do not have access or do not understand the internet so that they can obtain this information and safely access a licensee, whether it be a physician or anyone else in the healthcare occupation.
Thank you, Ms. Shipsky. Go ahead, Mr. Wright.
So as a non-physician and public member, I want to just make a brief comment, since I noticed a lot of the comments were, and the sort of the discussion is that this board is majority physicians, and I'm not. I don't have any medical background. Nobody in my immediate family is a doctor. And while I am somebody who uses a tablet and a smartphone frequently, I think it's important that people who don't generally have access do have access. So one of the things that I would support and encourage, as I hear my colleagues at the other end of the table, is if staff can figure out a way to craft this so that it is responsive to the consumer, because I'm somebody who's particularly interested in bias and digital divides, and I think that is a real thing and it is a real concern, and I support the concept of this, and so there has to be a middle ground for us to allow for some information for the consumer. If I go to a website and it says, find out some more information about your doctor, I'm going to click on that because that's friendly to my vision. Verify is something I might possibly ignore. I mean, I won't as an individual, but if I'm a consumer, I'd ignore it. So I would like to see staff maybe come up with some alternatives or something, that they can present to us that we could consider for our next board meeting in the interim.
Thank you. Dr. Levine.
So, excuse me. So, I have learned a tremendous amount through this process, and I want to thank the folks at Consumers Union who spent enormous amounts of their time in conversation with many of the members of the board in preparation for this meeting. And I think in a number of issues, independent of an up or down vote on this administrative petition, I think a number of issues have come to light that are very important to us as a board, both in terms of consumer protection, but also in terms of an affirmative, positive engagement of the public with the work of the board, its role in assuring a qualified, safe inventory, if you will, of physicians practicing in the state of California. And the clunkiness, if you will, of our website, the difficulty in finding your doctor among all the doctors with the same name, I think and I'm as guilty of this as anyone, the instinct to think we know best what consumers want, what information consumers want, and then to respond with technical language, and to jump ahead with tactics in the absence of a really coherent strategy. My guess is that a number of years ago, the Agency for Healthcare Quality and Research launched a very effective campaign with Consumers Union actually, called The Answer is the Question. And the intention was to provide consumers with accessible language, a set of questions to ask any physician or healthcare practitioner to get the information that was important to them. And while I absolutely agree that, do you have a license to practice, and is that license in good standing is one of them, it's not the only thing that consumers and patients want. And I'll make, this is a kind of an issue that I think is really important. We are all consumers and we are all patients, and we are consumers and patients at different points in time and in different points in our life. And when we are choosing a physician or choosing a healthcare plan or making a purchasing decision, we have a set of values and criteria we use to judge. And when we're sick and in pain and frightened, other things become really important. And as a medical board, I think we have to be conscious of, aware of, and responsive to both those sets of needs. I have concerns about the prescriptiveness and the I would say, the broad paintbrush of all probationers for the very prescriptive approach to notification. I absolutely agree we've got to address the internet issue and the user-friendliness of our website. We also, I think, need data. I mean, we need data about, and we've talked about this as a board. Our hope is that once Breeze is, fully up to snuff, that we'll actually be able to get predictive analytics from the system to be able to anticipate that subset of probationers who are at risk of reoffending. We have a lot of work to do. As I said, I have concerns about this administrative petition, about its prescriptiveness and the degree of detail. And I think we have issues we need to address. The notice that is now required in all physicians' offices. Truth is, it doesn't provide a lot of information. I'm not sure who understands what that actually means. It's certainly not in consumer accessible language, and it doesn't tell you what you can learn if you go to the medical board website. So we certainly have an opportunity to look at the notice. We have an opportunity to fix our website. I think we need to look at the public outreach, the very detailed and thoughtful set of approaches we heard from yesterday. And I think we need some time to think about how to respond to the legitimate request from Consumers Union to do something about ensuring that consumers and patients have the information they need and deserve.
Dr. Bishop.
I definitely feel the passion of the speakers today, and those of you who followed me the last few years know I don't lack passion, so I can recognize and really resonate with that. A couple years ago, Ms. Yaroslavsky and myself were tasked by this board to take on another very passionate item, and that was the issue of the prescription drug overdose death problem. And that's a critical issue, and we haven't perfectly solved that, but the way we went about that, I think, is what we should really consider doing here. This is not in any way meant to be a naysayer or to minimize what you're saying, but I do firmly believe that I personally could not vote yea on this today because I don't think we have all the information. We don't have all the answers. And to put into regulations something that is imperfect or doesn't even come close to perfection, I think I could not abide by. So I would, and this is informal, mind you, I would strongly advise that we take the same but very aggressive stance, very aggressive, with a couple public meetings of interested parties and really have it out, really fight it out. Get into the trenches and make sure this works, because I couldn't vote for this today and I want to vote for it. I want to make the public safer, and I want to make people have more access to this information. I just don't know how to do it today, and I don't think any of us know the right way today. So I'm just hoping that we can be very aggressive with this in the future and do it the right way and come up with a product like we did with the guidelines for prescribing opioids that I think is really a landmark. So thank you.
Dr. Lewis.
Yes, I'm not going to repeat many of my colleagues' comments because I echo many of them. I was hearing a lot about informing the public, those who don't have internet and the website and et cetera. And again, remind you all that we do have a newly formed committee, the Public Outreach Committee, and whose charge is to do that. And instead of rushing forward to adopting an idea that I also, too, do not have my hands around, I'm not there yet today to make any decision, that you allow the committee process to take all these comments from the public and from board members and formulate a aggressive, organized, well-thought-out plan to deal with some of these issues and then bring it back at a future meeting so we can all come together as a team and figure out how we can best inform the public. Again, I'm not here yet. I think this is overly prescriptive. I think we have probation from A to Z, some very simple things to some very egregious things, that this plan would require all patients to be notified. I think it would definitely, as Dr. Hawkins had alluded to, affect the doctor-patient relationship very much, access to health care. So I caution everybody that we need to step back, let that committee process work to try to answer these questions, and then have another more informed discussion at a later time. Thank you.
Dr. Yip.
Just echo my colleagues, my member. I do personally a lot of respect for the consumer. Probably will come today, spend hours preparing. What I'm going to say is not an excuse to say no today. In addition to my colleagues here, under the leadership of Ms. Wright, who's a public member, Panel A, we do at times require the decision to have the physician notify the patients in writing when they make an appointment what they cannot do. So there is something out there. Rather than a blanket yes today, as Dr. Krause mentioned, there's a system issue that will work together to bring this happen. I think the days would come when the doctor need to notify the patient that they're on probation. But let me give you an example from Panel A. We do have cases which is close already, so I can't describe with them as a name. There's some young doctor who have bright, great future, who are in probation because they have trouble with the training director. So those physicians would tell them, you have to tell your patient you're on probation. There's no way they can develop a great career in California. And we kind of kill one good physician.
Dr. Yip.
I think meanwhile what we can do.
Please refrain from talking about cases. It's not closed.
Sure. No. That was case. That was closed before. Yeah. No name. Okay. Anyway, what I'm saying that is, looking at the guidelines here, I think we have room to improve. Certain so-called egregious acts, sexual misconduct, etc. I think we can use that mechanism to require those violate physician to notify the patient that they need to notify that they're on probation.
Thank you, Dr. Yip. Mr. Osalski.
I think this has been a very educational experience for all of the members of the board to hear in such an organized and passionate, unified voice of what they feel is important for consumers in California. So we remind consumers in California, include doctors, as far as I know, that they also do avail themselves and their families of medical treatment. The issue that I have with this petition is that I don't know that what the intent is really what's going to happen. The intention is, from what I got from it, is that there should be the responsibility of the physician in egregious situations to notify their patients of what's going on, either when they make the appointment, when they show up at the office, or at some point. And in some of the cases, that happens today already. And there may be situations that is totally appropriate. It may not be appropriate in every situation. So how to do that and how to ensure that it's done in an appropriate, punitive, thank you, I get to my age, you do forget words. Non-punitive manner is what's important for all of us, because this is not a process by which we're looking to put any kind of letters on anyone's foreheads. We in California and we in the United States believe in second chances. We believe in redemption. We believe in giving people a second opportunity. And my concern is that once you put something out there, you can't take it back. So let's try and put it together in such a way where it's effective and it's going to make the best impact on the broadest amount of people. So to that end, I would suggest that there has to be more public comment, that it may be that, as Dr. Levine started to allude to, the notification that is currently in every medical office, every doctor's office, every hospital, every surgery center, that the medical board, the doctors are licensed by the Medical Board of California. Maybe that in fact has to go further. Maybe it needs more than an 800 number. Maybe it needs other information. But that's only one tiny opportunity step. There has to be others, and I think that you should all know that this board takes this very, very seriously, and you have been heard, but I'm not sure that the way it is outlined today, I can support it. And I've been grappling with this. I've been talking to people that I know as to what they would recommend. I've been getting suggestions from people, and I've been trying to grapple with this. And I think we all are. So I want to thank the Consumers Union and for those consumers out there in the community that have been participatory here. And I want to thank staff for their jumping on this and really hearing what's being said. They've listened and they've heard. And now as to next steps, I'm not sure if it's an interim meeting. I'm not sure if it's a public interested parties meeting. I'm not sure where it's going to go. But I assure you from my perspective that staff in this board is not going to let this falter and walk away, that there will be something that will come out of this. It might not be everything, but it will be something. And as we go forward, I think that there should be confidence in the public that what people are doing sitting here behind this side of the table is no different than what you're doing on that side of the table, except we're doing it a whole lot more often. So I want to thank you again for the opportunity to hear from you. And know that I personally take what you've said very, very seriously, and I know that every one of my fellow board members does as well.
I'd like to make a comment.
Ms. Pines.
I usually don't talk that much, but I definitely empathize with the Consumer Union and everyone else in the audience who's come up and spoken to us today. But I think that what we haven't thought about is all the unintended consequences of people who will receive a notice about their doctor. And especially being a person of color, what that would do to communities of color that don't have a lot of doctors to begin with, and most times don't go to the doctor for varying reasons, whether they're cultural reasons or other reasons that prevent them from going. And so I think that when I first came to the board and they walk me through the process and how they investigate a complaint, I thought to myself, this is incredibly detailed, and I would not want to be a doctor that would have to go through this process because everything becomes unveiled. And what I would like to see is the process of us looking at what would happen if this notice was to be received by every individual, and what the anticipated actions would be of people who would receive that, so that we can look at those things and start to consider those responses before we would move forward and make a decision to do this.
Thank you, Ms. Pines. Dr. Bolan.
Okay. I will probably be the last, besides our chair. I think it is very important what has been discussed here prior to this meeting for many years about how do we protect our consumers. I think what my colleague, Dr. Kraus, really resonated with me, because when he gave those cases, it just demonstrates that there are a lot of different actors and actresses in the healthcare field. And it's not just what happens in a doctor's office or in a hospital, but what happens in other places in which consumers are participating in something that can change their looks, going to beauty salons, to going to their doctor's office, going to a hospital. I think it is also very important to recognize that digital divide and those biases that exist. As a woman of color as well, I completely hear and understand the issues raised, but I'm also very concerned about the immigrants. This country that many of these patients forego care. We have 152 languages in Los Angeles alone, and we could say it's the top 1, 2, 3, 4, 5, 10 languages, but the idea and the strategies that have to be put forth in order that individuals, all individuals that are participating in care in some way, receive information is something more than I think we can do today. So I think that these campaigns, these community-based organizations, the passion that certainly the Consumers Union has to be brought forth to all communities. And we need to, if it means knocking door to door, those community agencies are there, and I think as has been stated, this board takes this very seriously, this staff takes this very seriously, and there's much more work, I think, that needs to be done. Thank you.
Thank you, Dr. Bala. I think that concludes all the board members, at least once. Only once was spoken today is me. Sitting in this chair restrains me somewhat. So, Ms. Webb, what are our available actions?
So the board can grant the petition, in which case it would move through the regular rule-making process. The board can deny the petition, in which case I would ask for a motion to authorize board staff with the assistance of the board president to craft the letter to send to the petitioners in the Office of Administrative Law. And that could include, in the denial, the plan for action outside of the petition. And the board can also deny in part or grant in part the petition.
Table the petition?
Oh, you can't. Okay. Yeah, just wait. Let me clarify some things before I take a motion. So we have options to grant or deny. What I want to make sure is that after if it is granted, it's fairly simple. We follow the procedure. If it is denied, I would also like to take a motion what further we would like to do from this board, like assigning it to a committee or assigning it to a task force to really work on the project. So with that, I would take a motion.
Mr. Chair, a point of order, can I just ask a question of council? Is another option, can we receive and file, then go forward by asking staff to do what it is we want, so that it's not necessarily taking a position on the petition at this point, but simply receiving and filing the item, which is done?
No, we have timelines that we have to comply with, and so it's...
Is it required that we grant or deny a petition, or that we can't receive and file the issue because it's on the agenda?
I don't understand.
Receive and file the issue means you don't take an action one way or the other on the issue, and then we can move forward asking staff to, and maybe the Public Outreach Committee, to take this issue up and...
Well, it's not an option provided under the government code, but this board has authorization, even if it's denied, to raise it at any time. So it doesn't restrict the board at a future time once it's been vetted as suggested by the members to come up with a solution that can reach an acceptable result.
All right.
Thank you. Dr. Lewis.
Yeah, I'm going to go ahead and make a motion. My motion will be to deny the petition and authorize the staff to send a letter to the petitioners of such, and then to craft further actions of this board and committee. Is that?
I would also ask that the board authorize the president to work with staff to draft this letter.
Draft the letter, and the additional committee.
Do we have a second?
Second.
Okay. Any public comment? Any?
So, Ms. Shipsky, I just want to clarify as to why the government code section says we have 30 days from the petition to grant or deny it. And so that's why we received the petition, I'm not sure what date, but we have to, within 30 days, act upon it, basically. And so that's why
I appreciate the answer. That's why I was asking.
I thought.
Thank you. Any comments on the telephones?
Mark, are there any callers with comment?
At this time, there are no phone comments.
Dr. Levine, you have a question?
I'm wondering, Ms. Webb, if, and I don't mean to volunteer you, by the way, without your knowledge, but I think if it's okay that we ask the president and vice president of the board, because I think in the process of crafting the response, it would be helpful for staff to have Dr. Gnanadev's perspective, given that he has heard firsthand all the testimony. So I'm wondering if that's a friendly amendment to the motion?
That would be acceptable if Dr. Lewis accepts the friendly amendment.
I will accept the friendly amendment of Dr. Levine.
Yeah, usually Mr. Serrano, Sewell, and I work very closely together anyway. Thank you. Thank you, Dr. Levine. Yes, sir.
Simple question. Am I to understand that if the petition is denied, that it's the sense of the board that there will be further work on this issue in committee?
Yes.
We'll take that, and as I said, that I would entertain a motion afterwards, and that it has to pass the board, but that is the process I'm looking at.
Could I request that my written comments, including evidence-based articles, be distributed to the members of the board for that process, please?
You can, anytime you want, you can send them, no problem.
You already have it.
Okay, roll call, please.
Hold on, we have another public comment.
Oh,
Lisa.
I just want to thank you for your comments. They're really appreciated. And we look forward to working with you as this moves forward. And I would say that I understand that people have some concerns with the prescriptiveness of this petition, and I would urge you to think about the substance of what it's trying to do. And we are very concerned with the serious reasons that people are on probation. We have not read all 500 orders, but I can assure you that the ones I have read, which are random, as people ask me to review them, and trying to identify those that are serious, they are all serious. And so think about those things. It's possible there are some that would not qualify, but I would encourage you to think about the really serious issues and to try to have a standard where certain violations of standards of care and behavior do get a requirement to notice on a standard way. What we've seen so far seems kind of random, but we don't see the whole story, and they may not be, but I do not believe that all of the sexual misconduct cases that require chaperones also require notice. I may be wrong on that, but if that should be consistent across the board. Those are the kinds of things that we're really looking for. So thank you very much for your discussion, and we look forward to working with you.
Thank you, Lisa. Julie, you want to talk?
Thank you, Dr. Gnanadev. Very briefly, Julie D'Angelo from the Center for Public Interest Law. I would ask that either in this motion or in a subsequent motion for follow-up work that you delegate to the Enforcement Committee a real in-depth look at the probation program, the method by which they detect violations, the method by which they bring those violations to the attention of the Attorney General's office, because if your probation unit is not detecting or forwarding violations, then patients are not being protected, and the data suggests that the process is not very robust. So I would encourage you to do that, and we stand ready to help you with that.
Thank you, Julie. We take it for granted. We don't even need a motion for that because that's the responsibility of the enforcement committee, and they will look into it. Okay, roll call, please.
Oh.
We did already.
The phone.
Any phone comments?
Mark,
No
are there
phone
any?
comments at this time.
Thank you.
There are none.
Want to repeat?
Ms. Webb?
Yeah, Dr. Hawkins asked that the motion be restated, and so please make sure that this is correct. This is my understanding, that the board is denying the petition and is authorizing staff and the board president and vice president to work together to craft a letter to be sent to the petitioners in the Office of Administrative Law. I understand there will be a second motion after that, but that's the first motion.
That's correct.
Roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Abstain.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip? Dr. Ganadev?
Aye. Now I would entertain a motion to either assign it to a committee or have a task force to work with all interested parties, including the Consumers Union.
So moved.
Second.
What's the
Right.
motion? Because there's two parts to that.
Okay, so,
He'll choose.
do you want me to say it, or are you going to say it?
I would
Okay,
like
so
you to go
I
ahead,
want to
Jimmy.
incorporate some of what we heard from the consumers. So, if I understand it, this direct staff to work with interested parties to come up with some suggestions or a plan for how we can incorporate at least some of the consumers' concern for informing the public about doctors who are on probation. If I can also add in, at that time, a way for staff to look at how it is conveyed on the website as well, to make it more user-friendly.
Can I just ask you to correct
I mean,
that?
it's scratch that.
Yeah, so just what I'm thinking is, this is for Mr. Serrano Sewell to appoint a task force to
Okay.
look into this, so that then they can conduct hearing if they need to, and then really come up to the board with recommendations.
Okay, then what you just said, I'll make, so moved, that's fine.
And I'll second that.
Okay, any discussion? Yeah.
And for Mr. Serrano Sewell and Dr. Ganadev to determine if it needs to go to a particular committee for further action.
No, I think the
Task force.
motion is for,
That's a separate-
the motion is for either, for
task force
a
or
task force or committee to be assigned by the
Or
chair
Yeah,
as
Okay.
needed to work with staff
and interested parties,
and interested parties to further the conversation.
yeah, so moved.
Okay, is it clear, Dr. Kraus?
Speaking in favor of the motion, and also wishing to acknowledge that our own staff has its hands tied at times regarding the website and other avenues of communication by requirements of the Department of Consumer Affairs and sometimes even the state legislature. So I was interested to know if there could be a friendly amendment to also include staff outreach to the Department of Consumer Affairs.
I'll accept that, yes, I will accept that.
Okay, so that is included in the motion.
Restate the motion.
I can restate it per my
Thank you.
understanding. That the board is authorizing the president to appoint a task force to look into this matter further and to do outreach to the Department of Consumer Affairs to get support on how better to improve the website and outreach.
I think it was committee, task force, or an existing committee
Okay?
to charge that as forward.
Yeah, task force or existing committee.
So, I'm sorry, Dr. Levine.
It's exactly correct.
So
Dr. Levine.
there are lumpers and splitters, and Jamie's a lumper, I think, and I'm a splitter. So I think there are three pieces to this. The first is, I think Ms. Felmuth's recommendation to the Enforcement Committee, which does not need a motion, as I understand it.
That's correct.
The second piece is, I think, within the purview of the Enforcement Committee, which is looking at the disciplinary guidelines. Is that what the intention is, that be?
No, I'm trying to get this task force to reevaluate the petition that we just denied. So the committee or the task force will work with interested parties to come up with alternatives to allow for figuring out in the next meeting or in the meeting future how we can go about making it more clear to the public when a doctor's on probation. That is not as prescriptive.
That's correct.
That was my motion.
So,
Okay, so are we clear?
So the object was not to change everything that is existing today as far as what the Enforcement Committee's responsibility was, but to rather add to a committee assignment or a task force the opportunity to further the discussion around the elements of this petition.
Yes.
Specifically.
That's my motion. Is that clear? I'm sorry.
That's the motion and the second.
To get some consumer input versus what the board
No,
said.
they were not.
I think we can separate out the directive to the Enforcement Committee. And
That's not part of my motion at all. No.
Thank you. Any public comment? Because you heard multiple versions of the motion, but finally you know what's real. Any comments on the telephone?
We have no comments on the telephone.
Thank you. Roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Jaroslavsky?
Aye.
Dr. Yip? Dr. Ganadev?
Aye. Thank you.
Can I make another motion?
Yes, we're getting there. I do want to, actually, I want to I'll take Dr. Levine's motion, but after that, we'll take a 5-minute break. I think you all worked very hard. And I do want to thank the consumers for patient protection for bringing this to our attention with the petition, even though it has a lot of holes, a lot of problems, but the idea behind is better patient information. I think that we'll take that very seriously. Thank you. We'll appreciate it. With Dr. Levine.
I just want to make a motion. I don't want to lose the piece about consumer outreach. And so I'd like to make a motion that Mr. Serrano-Sewell, if I get this correctly, ask Dr. Lewis, as chair of the Outreach, Education, and Wellness Committee, to take on the issue and perhaps a task force of 2 people to work with staff on refinements to the approach to consumer outreach to address both the issues of those without digital access, the accessibility of the language, and other issues that were brought up yesterday during the committee.
I think that was addressed yesterday.
Dr. Levine, I think that's part of the motion, and I can assure you that one task force member is sitting left to me here, who is the chair of the Public Outreach Committee. So I think we know what you meant.
I withdraw the motion.
Thank you. With that, we have 5 minutes break, and it's more than enough. We get to go home. Call meeting to the order again, and I was told that we also have midwifery students from Najomi Institute. Thank you for coming. Okay, so we're back in session. We have quorum present. So we'll go to item number 15. Discussion and possible action on legislation regulations. Ms. Amos.
Thank you. So first, I would like to report that I've contacted legislative offices in the San Diego area and invited them to attend our board meeting. The 2015 legislative session has ended, and the legislature does not reconvene until January 4th, 2016. This is the first year of a two-year session, so what that means, if a bill did not pass this year, it still has one more year to pass through the legislature. Please refer to your legislative packets. Actually, not a packet this time, it's tab 15, and there's a tracker list in your packet. The bills in pink are board-sponsored bills. The bills in green were signed into law by the governor. The one bill in orange was vetoed, and that veto message is included in your packet, and the bills in blue are two-year bills. We will be discussing all bills in green and pink that were signed into law. I will only be giving a brief summary of each bill and then discussing the board's implementation plan. If any members have questions on the specifics of the bill, please let me know. Of note, every implementation plan includes a newsletter article in the winter newsletter and notifying and/or training board staff. So I will not mention those items, but please know that they are included in the implementation plan. So let's start with the first bill in pink on your tracker list, which is SB 396 Hill. And this is the bill that the board unofficially sponsored related to outpatient settings. Just very quickly, it requires peer review evaluations for physicians and surgeons working in accredited outpatient settings. It allows accredited outpatient setting facility inspections to be unannounced. And it also allows accredited outpatient settings and a Medicare certified ambulatory surgical center access to 805 reports. And unrelated to outpatient settings, it also delays the report due date for the board's vertical enforcement report till March 2016. So the board's implementation plan for this bill is to include a standalone article in the newsletter geared towards physicians that work in outpatient settings. We also will be meeting with the accreditation agencies to explain the new requirements in the bill and ensure the accreditation agencies understand the new requirements and that we provide any needed guidance to the accreditation agencies. Board staff also plans on drafting an all facilities type letter for all accredited outpatient settings on the new requirements of the bill, including any guidance from the board, and sending a letter to the accreditation agency so they can disseminate that information out to all the outpatient settings. We will also update the board's website and work with board staff on processes to allow accredited and certified outpatient settings to access 805 reports from the board. And then related to the VE report, we will be working with DCA to complete the VE report by March 1st, 2016. And that was discussed in the Enforcement Committee yesterday. Okay, is there any questions on that bill?
Any questions? I know Jennifer is a speed talker, but go ahead. Next
okay.
one.
The next bill is another sponsored bill, SB 408, and that's the midwife assistant bill. And this bill ensures that midwife assistants meet minimum training requirements and sets forth the duties that a midwife assistant can perform, which are technical support services only. I can go through those if you would like. They're in your analysis. Moving on, the board's implementation plan is to notify DCA, Health Quality Enforcement Unit staff from the AG's office of this bill. We will be holding an interested parties meeting regarding training requirements for midwife assistants. And then taking the information that we receive in that interested parties meeting, we will work on updating and developing regulations to set forth the training requirements for midwife assistants. And this will be similar to the regulations that are already in place for medical assistants, but it needs to be geared more towards midwife assistants. We will need to update the board's website to include information on what is required to be a midwife assistant, what duties a midwife assistant can perform, and frequently asked questions. That's our implementation plan for that bill. Any questions? No? Okay. The last bill in pink is SB 800, and this is the omnibus bill that includes all the technical changes for the board that was signed into law. I can go over them if you would like. And really, our only item for the implementation is to notify DCA and the AG's office that these technical changes have been made. Questions?
Thank you, Ms. Summers. Any questions? This is your implementation, these are the three implementation.
Those are the three pink. I still have to go over the ones in green, so
Okay.
not done yet. Sorry. Okay. That would have been so nice and easy, huh? Okay. Okay, the first bill in green is AB 637, and this is a bill that allows nurse practitioners and physician's assistants under physician supervision to sign off on the physician orders for life-sustaining treatment forms. And our only implementation plan is to notify DCA and the AG's office of this change. Questions? Okay, moving on. AB 679, Allen, there's a number of bills this year that were guided and amended at the very end of session. So some of these bills you haven't heard about before because they were literally done like in the last 2 days or 3 days or last week of session. So if you haven't heard of them before, that's the reason why. AB 679, Allen, is the bill that basically extends the date for cures registration and law. So right now, before this bill was passed, it was January 1st, 2016. This bill extended it to July 1st, 2016. You know, everyone kind of knows the issues we're having with cures. Kim provided an update in her written material, so this is just really allowing more time before that registration requirement. So our implementation plan is to include a standalone article in the newsletter to let all physicians know that that date has been delayed. We also plan on sending an email blast out to all physicians to provide notification that the date has been delayed and updating our website.
Okay, go ahead.
Okay, the next bill, AB 684, is another one of those bills that was amended in the last part of session. And this has to do with the board's RDO program. So it authorizes the establishment of landlord-tenant leasing relationships between a registered dispensing optician, optometrist, and optical company. And the big part for this bill that affects the board is that it moves the RDO program from the board to the Board of Optometry. And so board staff spent a lot of time meeting with interested parties, meeting with the governor's office, all stakeholders, and this was one of the things that you know, we originally thought might be a 2-year bill to allow more time, but it ended up moving at the very end of session. And so, you know, there's various changes to, you know, enforcement. Now it allows the Board of Optometry to do inspections. It replaces one of their board members with the RDO board member. It makes a lot of changes, but it doesn't really impact the board anymore because really the biggest change for us is just moving the RDO program over to the other board. So for us, our implementation plan is really moving that program over. So we have to transfer all RDO program applications and files to Board of Optometry, allowing Board of Optometry to access the RDO program files in Breeze, updating the our webpage to let people know that now this is happening, it's in the Board of Optometry. We'll be working really closely with the Board of Optometry to train their staff, to make sure they have all the information they need. We're going to be working really hard to make sure it's clear that so consumers know that now the RDO program is under the authority of the Board of Optometry. So we'll have to be doing some transition stuff on our website and some transition things with Breeze, and just really ensuring, like I said, that all interested parties are notified that that change is effective January 1st, 2016. So that's our implementation plan for that one.
Okay. Next.
Move on. And I know some of these bills, because I've gotten contacted about some of them, there might be a public comment on each bill, so that's why I'm just like pausing for a minute. But so this next one, I believe there might be public comment. So AB X215, I'm sure you've all heard about this bill. It establishes the End-of-Life Option Act.
Did you finish all the implementation plans?
No, not yet.
No.
No.
Good.
Okay. It's just, yeah, all the bills in green, so we don't have too many more. Okay, so ABX 215 establishes the End-of-Life Option Act. As you remember, we talked before about SB 128, and that was in the regular session. So that bill became a 2-year bill. What they did at the, they took it, used the extraordinary session and introduced another bill that is very similar to SB 128, but it does have some additional requirements. The kind of interesting thing about this bill is it doesn't become effective January 1st like all of the other bills. Because it's a special session bill, it remains in effect until 90 days after special session ends. So we don't know when special session is going to end. It could be as early as when they come back into session on January 4th. So if that was the case, then it would be 90 days after that, but it could also be after that. So just moving through it, the Act gives a mentally competent adult California resident who has a terminal disease the legal right to ask for and receive a prescription from his or her physician to hasten death as long as the required criteria is met. The required criteria is, like I said, it's very similar. It's in the analysis. The one thing that does impact the board is in the bill, and it's included in your packet, there's actual forms included in the bill that the prescribing physician, the consulting physician, they have to fill out and maintain as part of the patient's medical record. And so the bill actually gives the board the ability to update that form if we believe it's necessary. So if we were to get input like that from consumers or from physician groups that the form should include additional information, the bill gives us authority to add on to that form. And so, the implementation plan is, once the bill becomes effective, to include a standalone article in the board's newsletter, to notify DCA and the AG's office of the bill, and to update the board's website to include information on the End-of-Life Option Acts and links to CDPH's website page. So CDPH is basically kind of, they're the department that's responsible for the data reporting on this bill, and so a lot of these forms have to be sent to CDPH so they can report on this data, and so they're going to have a web page with a link to the form, so we'll link up to their web page, and if any changes are made to the form that we think need to be made, they will update that form. So that's really the implementation plan for that bill. And I don't know if there's going to be public comment on the phone.
Yeah, I just want to first ask Ms. Webb, do we need any regulatory requirements for have to write any regulations for this?
Yeah, there's not an exception made in the statute to bypass the regulatory rulemaking process, and so that would be required.
Okay.
If we believe a change is made. So it's not in our implementation plan now because we don't know if a change is going to be made, but.
Okay, any questions from board members? This is an important bill. Any comment from public? Any comment on the phone?
We do have a phone comment, and again, I would like to remind our participants on the phones to mute their webcast before their comment. We have Dave Killerin.
Thank you, Mr. President and distinguished board members. My name is David Killerin. My wife, Maureen, is a hospice patient who's completely paralyzed by ALS, and we know many other ALS patients. So today, I'm speaking for a group of people who literally have no voice. And in fact, for many ALS patients, Medicare has actually locked out their eye gaze computers from accessing this webcast. So I speak for people who are unable to speak for themselves. Since clinically depressed disabled people are placed at high risk by the Aid in Dying Act, this board should adopt special continuing education requirements for doctors who counsel severely disabled patients about aid in dying. This is a historic new law, and it merits by the board than just a press release for the implementation. The new law does not just require patients to be informed about palliative care alternatives to aid in dying. It requires that patients be fully informed about those alternatives. Now, ALS patients often struggle with whether it's worse to be alive or dead. Studies show that with proper care and equipment, ALS patients can have a reasonably good quality of life. In fact, if any of you saw the Super Bowl, you saw a commercial that was narrated by an ALS patient with a special assistive communication device. But without proper care and equipment, it's easy for ALS patients to wish they were dead. And the leading cases about the right to die involve ALS patients. Too often, terminally ill disabled patients are not getting the care and equipment that's needed for their palliative and hospice care. Why? It's because their doctors don't know what equipment and care are available to these patients all the time. Or the doctors don't know how to prevent delays in the provision of that care and equipment after it's been prescribed. Now, the law that was just passed by the legislature allows the medical board to revise the attending physician checklist and to require continuing education about palliative care of severely disabled patients. So I suggest a motion to authorize the staff to recommend a multidisciplinary group to develop a curriculum for doctors who counsel severely disabled patients about aid in dying. And that can be included on the doctor's checklist. Now, obviously, this isn't ready to do today, but it needs to be ready before the law goes into effect. This is a matter of life or death for severely disabled patients like my wife and our friends with ALS. We are in the crosshairs of this new law. And I sincerely hope the board takes action. Thank you for your consideration.
Thank you. Any other comments?
We have no further phone comments.
Thank you. Ms. Simmons.
Okay. ACR 29, Fraser makes finding and declarations related to declaring April 2015 as DMV Donate Life California Month in California, and there's no additional implementation items for that resolution. So moving on, SB 19 WOLC establishes the California Physician Orders for Life-Sustaining Treatment e-Registry pilot. We had talked about this bill before. It was significantly amended to make it a pilot project, and now the Emergency Medical Services Authority is charged with establishing the pilot, and the purpose of the pilot is to collect patients' pulse information received from a physician or their designee and disseminate that information to an authorized user. This bill now only allows the bill to be implemented if sufficient non-state funds are available, and there's no additional implementation items for that bill. So moving on. SB 277 PAN, this is the bill everyone knows that eliminates the personal belief exemption from the requirement that children receive specified vaccines prior to being admitted to any private or public elementary school or secondary school or daycare center. I can go into more specifics, but I think everyone knows this bill. So our implementation plan is to notify DCA and the AG's office, update the board's website to include information on the new vaccine requirements and medical exemptions, including what a physician should consider before issuing a medical exemption. This has come to me, I've gotten calls on this as a possible enforcement issue, like who can file a complaint against physicians for inappropriately issuing medical exemptions. So this might be something that we get a lot of calls on once it becomes effective, so we just want to be prepared for that. We need to update our cite and fine regulations to include improper medical exemptions or noncompliance with the provisions of this bill as well. So that's the implementation plan for that bill. No one has questions? Move on to SB 337, Pavley. This is a bill that was briefly talked about in Dr. Bishop's update yesterday. This establishes alternative means for a supervising physician to ensure adequate supervision of a PA for routine care and the administration, provision, or issuance of Schedule II drug orders. And so it made some changes, like added the medical records case review meetings. It changed the counter-signature requirements. The board had a support position on this bill, and the implementation plan is only to notify DCA and the AG's office and update the board's website. No questions? Moving on. SB 464, Hernandez. This is a bill that authorized specified healthcare practitioners to use a self-screening tool that will identify patient risk factors for the use of self-administered hormonal contraceptives by a patient, and after an appropriate examination, to prescribe, furnish, or dispense self-administered hormonal contraceptives to the patient. The board's only implementation item is to notify DCA and the AG's office. There's no questions. Moving on to SB 643. This is another bill that was like at the end of session. You probably heard about the medical marijuana bills. They were kind of moving around. We've heard about a lot of, it has the same elements as some of the others. It's just a new number. So basically they divvied up the regulation of medical marijuana into 3 bills. And so now the bill that affects the medical board is SB 643 McGuire. And it's, like I said, part of one of the 3 bills that establishes a regulatory framework for the cultivation, sale, and transport of medical cannabis. And they created a new Bureau of Medical Marijuana Regulation in the Department of Consumer Affairs. There's a lot of different state entities that have pieces of the regulatory control, including the Department of Food and Agriculture. But the portions of the bill that impact us, like I said, are very similar to previous medical marijuana bills. So it includes cases related to marijuana recommendations in the board's priorities. It actually does it a little different. It creates a new section in law that's only related to recommending medical cannabis, and so they kind of restructured the way the law was written, but we made sure that it included the appropriate, if something had referenced a section of law before, we made sure that it included the new section of law. So all those technical fixes were made, and they actually made it into the bill that got signed. So it still states that physicians recommending medical cannabis to a patient for medical purposes without an appropriate prior exam and a medical indication constitutes unprofessional conduct. Prohibits a physician from recommending cannabis to a patient unless that physician is the patient's attending physician. It includes the same advertising, financial kickback, and employment restrictions. And it also requires the board to consult with the California Marijuana Research Program on developing and adopting medical guidelines for the appropriate administration and use of cannabis. So those are all kind of elements that we've talked about before. So our implementation plan is to notify DCA and the AG's office, include a standalone article in the newsletter regarding the new requirements for recommending medical cannabis. And then the biggest part here is that we would update the board's current statement on recommending marijuana and consult and solicit input on needed revisions, and then update the board's website.
Okay. This is make sure that especially people who are prescribing, they are aware of what the new law requires.
Exactly. So now it's putting our priorities, but it's also they have to do that appropriate prior exam. So that's something that was really important to us, and it made it in the bill, so that's a good thing. Okay, moving on, SB 738 Huff. This is a bill that provides liability protection for physicians writing standing order prescriptions for epinephrine auto-injectors for school districts, county offices of education, and charter schools. So our only additional implementation item is to notify DCA and the AG's office. And next bill is SJR 7 PAN. It's actually a resolution, and it urges the Congress and the President to renew funding for the Health Resources and Services Administration's Teaching Health Center and Primary Care Residency Expansion Graduate Medical Education Programs, and to lift the freeze on residency positions funded by Medicare to expand physician supply. And there's no additional implementation items other than what we normally do. So that concludes part 1 of 15.
Jennifer, so what does exactly, this is such an important issue, what does this bill do?
So it's a resolution, so it basically urges, so it's not a requirement, but it's basically saying California believes, you're writing into the federal government basically saying California believes this is really important and that you should do the things I kind of read. So it's not a requirement, but it's something that we thought it was important to support.
So actually, state of California did not come up with its own money for graduate medical education yet.
Not yet.
Are you offering?
It's unfortunate because that's where the bottleneck is. It's not the medical schools, it is the residency programs. It's unfortunate that we're there. So I want to make that public comment. So. Any public comment on all these? Any comments on the phone?
Okay, so moving on to 15B, which,
No phone call.
Okay, thank you. 15B.
Okay, so this is the 2016 legislative proposals. So the first one that's on here, I think we've heard that
15B.
verify may be changing, but it doesn't really change the purpose of our proposal. So as we heard yesterday, board staff is working on an outreach campaign. It's going to be discussed more at the next committee meeting. But part of the plan is to focus outreach efforts in March. And staff thought that it might really bring in legislative participation if we sponsor a proposal that would do a resolution to proclaim March as whatever we decide are to check a doctor's license month, verify a physician's license month. And, that could really go along with the visit our legislative day and just kind of bringing that campaign together. So that's the proposal, to have a resolution.
Given Dr. Krause's eloquent comments during the administrative petition section of our meeting, I wonder if it would be worth modifying this to be a DCA-wide, I don't know how to do that procedurally, but.
The only, I mean, I think that's a great idea. The only thing is it's a little different process if we want DCA to be involved because they have a whole approval process. So DCA would have to approve it. It would have to go to the governor. They would have to approve a proposal. I mean, I think it's a good idea, but I just want to let you know it's a little different of a process when I could definitely submit them a legislative proposal for that.
So it doesn't have to be either or, it could be both and.
Could be both, yeah.
Okay. Just plant the idea and we proceed with
Okay.
our intention, okay.
So I would need a motion, though, if you want to approve
Yeah,
that.
Jennifer, can you call exactly what you want?
What motion you want?
Motion to approve the.
In a little slower pace.
Okay, a motion to approve the proposal of verify or check a doctor's license month and/or work with DCA to make it all boards, right?
Do we need a legislative resolution to do it?
Yeah, I mean, yeah. Well, I don't know who else would proclaim
We're not
it.
proposing legislation for it, we're proposing it as a,
This is
public
part
info-
of the plan is to also do a resolution, which I would need a motion on because I would go to the legislature. We don't have to include a resolution as part of our plan.
You mean a certificate of congratulations is what you're looking for?
No.
It's called a resolution when you do it in the legislature.
Let me have a Ms. Kushman.
So as you've seen, even in what Jennifer has put in for some of the other dates, Donate Life has done this. What's another one that has done this? Prescription drug abuse was one. It's just a resolution that goes in and the legislature supports it as a resolution, that making it very important. It's not a document, it's not anything. It's a resolution that goes through the legislative process. The reason we wanted to do this is because we think it brings heightened awareness and because it helps the press be able to pick up on it as well. Because like Donate Life then did a big event at the Capitol and had legislative offices there. And so we're trying to bring the same awareness under it that way.
Okay, so I'll move for motion.
Okay, so we have a motion and seconded. Any further discussion from the board?
Let's just get the language right.
Yeah, let's get a plan in place before we go.
Before we
and
submit the resolution.
Yeah, let's be ready for this.
I'm sure we'll check on that, but Jennifer said it twice, so, Dr. Kraus.
I would be hesitant for us to put in concrete the name of this month.
Right, I said that's.
We could call it Trust and Verify Month, but that's, I think we should approve designating the month without necessarily micromanaging the name.
And really, right now, I just need approval so I can try to find authors in the break before the legislature comes back, so we will have time to work out the
Get your
name.
authors tonight. Don't worry about your authors, worry about the plan.
Okay, so I guess this is a friendly amendment. So any further discussion at the board?
Can I just ask a quick question? Is there a Consumer Protection Month designated in the state of California?
I will have to research that. It would seem like that there should be.
Consumer Protection Year.
We know that, but maybe if, when we're working on language, if we can, because that's really our mission, so maybe not, and you're right, it's not just a month, it's every day of the year. But if there's some way we can tie that in, that might get public attention a lot more than Trust and Verify.
And, I can always come back in January with actual language that you guys can approve before we move forward.
I would suggest you take Dr. Kraus's recommendation that a proven concept without too much detail.
Okay, and I have some audience. Genevieve, your name is on 15. I'm not sure which 15. You still would like to speak? Thank you. And Yvonne, you are on 15B. Okay. Thank you. Any other public comment? Any comments on the phone?
No phone comments.
Thank you. Ms. Toof, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines? Aye. Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Yes.
Dr. Gonadev?
Aye. Okay, next, Jennifer.
Okay, the next bill, So board staff has become aware of a growing number of cases that result in discipline because a licensee either has some type of disability that impairs his or her practice, but that licensee doesn't apply for a disabled license. And many times these cases result in a patient care incident and related discipline. Board staff is also seeing the same issue for older physicians who continue to practice, although they may face some cognitive issues. Many of these physicians have had long, distinguished careers, which unfortunately have to end in discipline. Both of these types of cases are difficult cases to settle. Many of these physicians have not had prior discipline, but they do not want to surrender their license. For physicians in this situation who are facing an accusation that would result in more than a public letter of reprimand, but less than revocation, the board is suggesting a new option for discipline, and that option would be resignation of license. The resignation option would allow a physician to voluntarily resign, but not allow the physician to reinstate his or her license. So basically, a resignation, the difference of surrender and resignation is that you're resigning, but you can't come back for a reinstatement like you could if you surrendered your license. And board staff believes that a resignation option might be more desirable for the disabled or older physician and would ensure patient protection by taking that physician out of practice in California. It would only be an option for the board to consider for discipline, and it would be up to the board to decide if that particular option is appropriate for each particular case.
Okay, it's up for discussion. Mr. Eslowski.
I just have a question. So, under these circumstances, does someone retain the title MD after their name or not? Or is it MD retired?
MD is actually a degree, it's not a license.
So it doesn't become part of the license?
I mean, you need to have an MD to get licensed, but you don't need to have a license to have an MD, because MD is granted by the university where you
So you maintain it? I'm not sure, that's what I'm
I'm
asking
looking
the
to
question.
Carrie and Kim on this because they've kind of worked on the language.
I'm not sure, that's, I'm asking the question because I'm not sure.
So an individual's license who's revoked or surrendered, they cannot use it if they're
Correct.
holding themselves out to be a physician. They
Right.
can't use the MD or doctor.
Correct.
And that's specific in the law. So when we go through this, we're going to have to look at that and make that determination as well, whether we include that license type as well in the status.
That's why I was asking the question.
And there would have to be a limitation that if they were allowed to use it, it couldn't be in a circumstance where it could be misleading.
It could be stated as retired?
Yeah.
Yes, okay, that's,
And I think that's really important because that is the thing that physicians will hold on to literally until the very end. It's the last breath. Seriously, so some way to designate
retired.
the status or the past status without being misleading
So it could be MD retired, but you can figure
or
it out.
something. Yeah.
Retired. Emeritus. Any other questions?
So I would move, do you want a motion to that effect? So
No, yeah, go ahead, please.
You want a motion, then you want discussion, and
Yeah,
you have-
then
okay,
afterwards.
Then the vote, yeah.
Yes,
done.
go ahead.
So I would move to, a motion to have this option available to staff to look into, to come back with the language and then get a, legislative fix.
Have a second?
Second.
Okay, further discussion. Comments from audience? Is this the one you want to comment? Okay.
Yvonne Chung with the California Medical Association. We actually just had a clarifying question regarding the difference between surrender and resignation. The proposal as listed in the agenda says that the license cannot be reinstated and that a surrendered license cannot be reinstated. It was my understanding that is that a surrendered license cannot be reinstated. They must reapply for a new license. Is that? Or I just wanted to kind of clarify what exactly we were talking about, is whether or not they could apply for a new one or whether or not their existing license could be reinstated.
So for a surrendered license, it can be reinstated. They have to file a petition for reinstatement and come back in that way, and then it goes through the disciplinary side or through an administrative law judge. They can't just file an application. So surrender or revocation have to come back through a petition for reinstatement. This particular license would be non-reinstatable and non-renewable. So that would be it.
All avenues would be
All avenues
closed.
would be
Okay.
external, yeah.
Okay, thank you.
Any other public comment? Comments on the phone?
No phone comments.
Thank you. Any other comments from the board? Roll call, please.
Dr. Bolott? Aye. Dr. Bishop?
Aye.
Dr. Hawkins? Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines? Aye. Ms. Shipsky?
Aye.
Ms. Wright?
Yes.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Aye.
Dr. Gonadev?
Aye.
Okay, the next set of proposals is some cleanup, but it's basically cleanup that's too substantive to include in omnibus. So you probably remember last year we had some allied health cleanup, and it was things that we have in place for physicians, but we don't have in place for allied health licensees, like taking disciplinary action for excessive use of drugs or alcohol, to revoke or deny a license for registered sex offenders, to allow allied health to petition license for reinstatement, and to allow to put these licensees on probation. So we tried to put it in the omnibus bill last year, but it got taken out because basically they thought it was too much for omnibus bill. So what we would like to do this year is to have a bill that would be a standalone bill that would include all these cleanup items. So we have those that I just stated for allied health, and there's also some for physicians. So as some bills were going through last year, we realized that law was incorrect as it stated the board's authority over the Board of Podiatric Medicine. It was being kind of used as an example of how we oversee Board of Podiatric Medicine, but we really don't. And so we realized that that definitely needs a cleanup, and that will include moving some stuff, deleting some things, and moving some stuff from our sections to the Board of Podiatric Medicine. Another thing that was from last year is our authority to deny PTALs. So right now we use the same things we do to deny a physician's license to deny a PTAL, but we really don't have clear authority in law to do that. So we would need to just do an easy amend to give us that authority. The other one is the board currently has a limited practice license that applicants or disabled status licensees can apply for, but the way the law is written, only new licensees or disabled status licensees can apply. And so if you're already a licensee, the way the law is written, it doesn't allow you to apply for that license. That was obviously a drafting error, so we need to fix that. Currently, also when the board physician is on probation, all related discipline documents are available on the website. However, it doesn't specify in law if you're a licensee and you're a probationary licensee. So if when we issue the license, we issue a probation license, there's nothing in law saying how long that stays on the website. So basically, when that probation is lifted, it just gets removed from the website because there's nothing in law that says, okay, it stays on for this long. And so we would like for it to stay on as long as probation stays on for licensees. And then the last fix that we are suggesting is existing law related to investigations that involve the death of a patient allows a patient that's died, allows the board to inspect and copy the medical records without authorization of next of kin if the board provides a written request to the physician that owns the records and proves they've made a reasonable effort. The problem we're running into with that is the physician doesn't always have the records, so they may be at the hospital or the place where the care occurred. So we're running into an issue because although we can request those from the physician, they don't have them. So we need to amend law to extend that also to the healthcare facility where the records are located. So these are just some kind of cleanup things that we've encountered, and they're basically too much for an omnibus bill, so we just need to run a bill to kind of include all of our big cleanup that we need.
So I would move that we put together this allied health licensing cleanup bill to take whatever issues that are necessary that couldn't be included in the omnibus bill to make us, on a go-forward basis, complete.
And it's also not just for allied health, it's also physicians.
Okay, then you've got to change I was just taking it from the title from your.
Okay.
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 So whatever cleanup is necessary for the medical board to be doing what it's supposed to be doing, we should be doing. I'm surprised though it couldn't be included in the omnibus bill or a separate omnibus bill.
Not everyone agreed that it could be included. It got put in and then it got taken out.
Okay.
I thought it should be in there.
Okay, do we have a motion? Do we have a second? Okay, any discussion on this? This will come back to us, so you just want to make sure that you're aware of. Any public comment? Audience? Okay. Any comment on the telephones?
We have no phone comments at this time.
I just have a clarifying question. If we were to call it an omnibus bill, everyone would know what we were talking about. So should this be our own omnibus bill? Is that?
Omnibus is really cleanup. That's
cleanup. This is what
the
this
difference. The only difference between an omnibus and a regular bill is the committee takes it on, and it's only.
So we can't be the omnibus.
We can't be the committee. We're going to have to find an author. Yeah, that's kind of the big difference.
Okay. Any further comments, questions? If not, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Yes.
Ms. Jaroslavsky?
Aye.
Dr. Yip?
Aye.
Dr. Gonadev?
Aye.
Okay, the next item is our omnibus technical cleanup. These are the things I think will actually be non-substantial and they can get in the bill. So one of them is to delete a section related to a task force that no longer exists. Another one is to delete a section related to the Bureau of Medical Statistics that doesn't exist. One section is to delete, it's related to retention of complaints, but it's not really relevant because the board has its own records retention schedule, and another section of law already applies, so it's not really relevant. And then also related to the limited practice license, the section requires the applicant or licensee to sign an agreement, but it doesn't anywhere say that the board has to approve that, and so we want to make sure that's clear. So those are the omnibus kind of really technical items that we would like to be approved to include.
I'll move to approve the omnibus bills.
Second.
Any discussion? Any comments from the audience? Yvonne?
Yvonne Chung with the California Medical Association. We'd actually like to request that the provision related to Business and Professions Code Section 2441, we believe is more appropriate for the major cleanup item rather than omnibus. This basically says that it clarifies that in the case where there's a limited practice license, the board has to agree to what the reviewing physician is recommending. We believe this requires further discussion regarding the situations in which the board would be substituting its judgment for the recommendation of the reviewing physician. Thank you.
Okay,
There's no problem with moving that to the major cleanup legislation.
Okay.
You said there's no problem?
Yeah, that should be fine.
Okay, any comments on the telephone?
We have no phone comments at this time.
Thank you. Any other audience comments? I want to make sure we're not missing. Thank you. Roll call, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Jaroslavsky?
Aye.
Dr. Yip?
Aye.
Dr. Gonadev?
Aye.
Now we're at 15C.
Okay, so status of regulatory actions. Ms.
So,
Moss, please continue.
The regulations matrix is in your, under tab 15, the last item there. I can answer any questions you have on the matrix, but 15C1, I would like to provide an update to the board regarding the regulations that would allow the board to accept ABMS Maintenance of Certification, CME, as meeting the board's CME requirements for license renewal. The board has received information from ABMS that all member boards' Maintenance of Certification, CME, meets the medical board CME requirements, with the exception of one ABMS board, the American Board of Pediatrics. And this board is slated to meet the medical board CME requirements in January 2016. So with this information, the proposed regulation really isn't necessary. So board staff is suggesting that this regulatory proposal be withdrawn. So I'd need a motion for that.
So moved.
Okay, so we have motion made and seconded. And
I'm
do
sorry.
we have any further
Dr.
discussion?
Levine, you recused yourself before on this issue, so maybe the motion should be
I'll
made by
make the
someone
motion.
else.
I recuse myself again.
I'll make the motion.
So we have
So
motion made and
exciting.
seconded. So any discussion at the board? Actually, I do want to thank you guys for getting this clarified. This was a major issue, and this helps quite a bit. Any audience comments? Any comments on the telephone?
No telephone comments.
Thank you. Roll call, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
I have to abstain.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip? And Dr. Gonadev?
Aye. Okay.
Okay, and then Ms. Webb is going to present on 15C2.
Yeah, 15C2. Ms. Webb, can you discuss the regulations and disclaimers and explanatory information? What is this?
This is explanatory information that appears on our website on the physician's profile, and board staff had started working on this quite a while ago, and upon further review, one of the sections in the modified language was based on law. There has since been a statutory change, and so that needs to be reflected in this language going forward. And so I'm requesting a motion for a 15-day comment period where the language in subsection 10 on misdemeanor conviction is amended, and I've highlighted it in yellow to make it easier to see there. So we need authorization to notice it for a 15-day comment period. If we don't receive any negative comments, then I would ask for authorization for the staff to complete the rulemaking file, put it forward to the Office of Administrative Law, and to take care of any non-substantive changes required to complete the process.
So moved.
Second.
Thank you, and I do want to make sure that motion says certain things. The motion to amendment and regulation to notice 15-day comment period. In addition, the motion should authorize the executive director to finalize the regulatory package and submit it to the Office of the Administrative Law if no negative comments are received. So I just want to clarify. Yes, Dr. Kraus.
In the modification of the text, it refers to highlighted double strike through, which is highlighted and double struck through. It has self-deleted. So should it be rewritten without the highlight and the double strike through?
Ms. Webb.
This is just to make it easier for board members to see. The double strike through is changes per this request. The modified language won't have all of these characteristics.
I agree with the intent, but as written, it is self-deleted.
You'll have to forgive me, I'm not sure I understand what you mean by that it's self-deleting.
Because it's highlighted and double struck through.
Just highlighted.
We can pass with the intent, but I think the document requires cleanup.
Okay, I'll have Dr. Cross work with Ms. Webb, because I think it's one of those language issues which
I just need to make sure. I can't let it go because I need the authorization for this regulatory package to be specific. And so
The regulatory package, the highlighting doesn't go into the regulatory package, it is for our visual help.
So this language is not included in the regulatory package,
The highlighting,
the modified text.
the modified text is, but the
Carrie?
I think I can try to explain. So when we originally noticed this, how we noticed regulatory language is it's a single underline and a single strike through with anything you're deleting, underline for anything that you're adding in. So now, in order for us to show everyone what the new amendment is, we kept the old, but then on, so 15C 2-3, you'll see that we have now the double underline is adding the double strike through is taking out what we had originally put in there. So it's an amendment on what we had originally amended.
Oh, I
Is that-
understand.
Okay.
He knows exactly what he's saying.
But as written, it has self-deleted. So for example, if it were to reread, changes to the originally proposed language are shown by highlighted double strike through, and then parenthetically, illustrate the highlighted double strike through, then it would be more appropriate.
So how about this? I'm going to read it the way it's going to read when the actual language gets done, and that way everybody understands. So it will read 10 misdemeanor conviction, California Business and Professions Code, Section 2027B5 states, all misdemeanor convictions resulting in a disciplinary action or accusation that is not subsequently withdrawn or dismissed shall be posted on the internet. Upon receipt of a certified copy of an expungement order granted pursuant to Section 1203.4 of the Penal Code from a licensee, the medical board shall, within 6 months of receipt of the expungement order, post notification of the expungement order and the date thereof on its website. And so our motion is to request that that is the language that we will use.
Okay, so Dr. Cross, did you get clarification? I know we have a motion, but did you get your clarification?
I'm satisfied.
Okay, thank you. So, roll call, please. Did we have public comment on this? Now I'm losing it. Public comment? On the comments on the telephone?
None at this time.
Thank you. Roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Yes, aye.
Hines?
Aye.
Ms. Shipsky?
Yes.
Ms. Wright?
Yes.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Aye.
Dr. Gonadev?
Aye. Thank you.
If there's no questions, that concludes my
Oh,
presentation.
Jennifer, you did a yeoman's job. We really appreciate it. We even are totally really getting your speed of talking, so, yeah.
I just wanted to go back on the resolution. It's fortunate that we have webcasting, so I thank the Department of Consumer Affairs because staff does watch, and I just want to let you know that there actually is a National Consumer Protection Week that is March 1st to 7th. So
There's nothing
March
on
is
the
a good
California
month.
site, so it's good. There was nothing on the California site, I checked.
Let's go on to 17.
Thank you, Ms. Kirschmeyer. The next item is number 16, update from the Department of Consumer Affairs. Ms. Lally, thanks for coming.
My pleasure. Thank you, board members and Vice President. Again, my name is Christine Lally. I'm the Deputy Director for Board and Bureau Relations with the Department of Consumer Affairs. And just before I start my update, I just wanted to personally, on behalf of the Department Director, Director Kadani, who I've been corresponding with, sharing the consumer public comments today, as well as the board members' comments. So we'll be sure to update when I get back to Sacramento, the executive team, as well as Director Kadani on what was shared today. So thank you, everyone, for their input, and make sure that we're working with your executive director. So thank you again. First off, I wanted to start with an update to the department's executive team. After 38 years of state service, Amy Cox O'Farrell, our Deputy Director for the Office of Information Systems, which is our IT division, just announced her retirement here in December. Amy is an extraordinary leader, and we are so fortunate to have had the opportunity to work with her and learn from her. She will be missed immensely. But I am happy to report that Amy is leaving the department in excellent hands. Jason Piccioni, who is my colleague who's here with me today, has been appointed Deputy Director to follow Amy's lead. With over 15 years at DCA, Jason most recently served as the department's Chief Technology Officer and shares Amy's can-do and will-do attitude that I think your Executive Director and board staff will attest to. You will hear from Jason later on in the agenda item 18. Jason will provide you an update on the BRIE system. We're very proud of Amy, Jason, and all of their accomplishments. Next, wanted to follow up on an update that I provided at the July board meeting regarding the department's pro rata study. As a result of the findings of this study, the department has moved its annual cost distribution meeting with the boards from January until November 17th at the department's headquarters in Sacramento. The primary purpose of this November 17th meeting is to give all boards and bureaus information regarding the distributed costs of the department, or as it's commonly referred to, that you probably have heard it referred to as pro rata. What will be different this year is that the various units within the department, such as our legal, public affairs, budgets, information technology, Division of Investigations, and the list continues, will have staff available to answer questions and discuss the services they provide to the boards. We believe this open house format will allow the boards greater opportunity to connect with the units they are currently working with, as well as explore other services they may have not yet utilized. The department is always seeking new ways we can assist the boards and bureaus with providing higher quality services, and we look forward to the medical board team joining us on November 17th and providing us feedback. Next, nearing the end of yet another year, I can't believe how fast it's gone by. I wanted to take this opportunity while I have a captive audience to remind board members of the importance of their required trainings and to be current on those required trainings. And those include, as I'm sure you could probably all recite to me, your board member orientation training, ethics training, sexual harassment prevention training, and driver's training. Just as a reminder, 2015 is a required training year for sexual harassment for all employees and board members of the department. So if you haven't yet completed it, please give me a call if you don't know where to access it, and we can get you signed up and get you on the next webinar. And if you ever have any questions regarding the required trainings, just please reach out to me, and I'm more than happy to assist. Finally, just wanted to update you also on the same line as required trainings. One of your favorite forms that you're required to fill out, the Form 700 Conflict of Interest filing. As board members, you know you're required to complete the Form 700 Statement of Economic Interest upon your appointment to the board every April 1st annually, as well as upon leaving the board. We heard the need shared by executive officers and board members for a more convenient system to file the Form 700s timely and accurately. And we are very excited to announce that 2016 will be a paperless and more efficient new year. To achieve this for the department's nearly 1,600 designated Form 700 filers, I'm excited to share with you that the department has purchased an online Form 700 filing system called NetFile. NetFile is web-based and currently used by several city and county governments. In addition to going paperless and the ability to file Form 700 securely and conveniently online, the new filing system will also provide custom notification to board members and department employees, ensure minor errors are corrected before filing with the Fair Political Practices Commission, will enable board staff to monitor the status of each filer's forms, as well as run management reports to ensure the Form 700s are filed on time. In preparation for the April 1st, 2016 annual Form 700 filing deadline, just got to get another plug in for that, mark your calendars, access to the new online filing system will be available in February 2016. At this time, the department will distribute a revised conflict of interest procedures memo to all filers, as well as the necessary training modules in order to properly educate, register, and prepare users of the new paperless system. That concludes my update from the department, and if there's any questions that I can help with or messages you'd like me to take back to Director Kidani, I'm more than happy to.
Ms. Lally, thank you for coming. Our biggest issue is Breeze. We spent enough money. It's $6 million plus $3.5 million, I guess close to $10 million. We're still somewhat lost. Where are we going? So just want to make sure that you're aware, but also I spoke to your CIO today. In my mind, there is no reason why consumers can't go to a website and put a Google search with a last name and everything pops up. So why can't they find out that kind of information rather than complicated way of looking at licensees? And so there are so many. So I think if you work with our staff, it really will help you and helps us and helps the consumers to really make it ease in going through the system. Any questions to Ms. Lally? Thank you.
Thank you.
Any public comment? Any comments on the telephone?
We have no phone comments.
Thank you, Christine.
Thank you.
Okay, next agenda item is item number 17, presentation and discussion on the North Carolina State Board of Dental Examiners versus FTC decision and Attorney General's opinion. Ms. Dobbs and Ms. Webb.
So, this North Carolina State Board of Dental Examiners versus Federal Trade Commission is a decision by the U.S. Supreme Court that was decided on February 25th of this year. And it is important for members of regulatory boards nationwide because it deals with state action immunity in antitrust cases. And I'll explain a little more. It came about because the North Carolina Board of Dental Examiners, which, like the California Medical Board, is made up of a majority of practicing licensees, sent out cease and desist letters to non-dentist teeth whiteners, claiming that they were engaged in the unauthorized practice of dentistry. Ultimately, the non-dentist teeth whiteners stopped offering these services in North Carolina. The Federal Trade Commission found that the dental board's actions violated the federal antitrust law and sued the board. The board argued that its actions did not violate the law because it is a state agency and therefore immune from antitrust law. The case went all the way up to the U.S. Supreme Court, which held that a state board on which a controlling number of decision makers are active market participants in the occupation the board regulates must satisfy active supervision requirements to get antitrust state action immunity. Now, some things to point out about the North Carolina Dental Board is that teeth whitening was not covered under the definition of the practice of dentistry. The dental board did not have statutory authority to pursue individuals for unlicensed practice, and they did not even attempt to make a case for public protection to justify their actions. Not that that's a controlling issue in this case, but it is important. And although the North Carolina Dental Board's authority is quite different than the medical board's authority, it is important for members here to understand the decision and its implications. The case prompted Senator Hill to request an Attorney General's opinion on what constitutes active state supervision. The Attorney General's opinion stated that active state supervision requires a state official to review the substance of a regulatory decision made by a state licensing board in order to determine whether the decision actually furthers a clearly articulated state policy to displace competition with regulation in a particular market. The official reviewing the decision must not be an active member of the market being regulated and must have and exercise the power to approve, modify, or disapprove the decision. That's in sum. The Attorney General further found that there are some broad areas of operation where board members can act with reasonable confidence that their immunity will remain intact, such as in disciplinary decisions, actions required by statute, adoption of safety standards based on objective expert judgments, and in regulations, except that market-sensitive regulations will require extra care. And further discussion is being had on these issues. The Federal Trade Commission has also recently come out with guidelines relating to this decision, And both the Attorney General's opinion and the FTC guidelines make it clear that changing the composition of the boards to have a majority of public members will not necessarily shield board members from antitrust liability. The Attorney General's opinion made some suggestions for increasing active state supervision, and these are all under review by the legislature and other stakeholders. The Attorney General indicated that a state cannot grant blanket immunity for anti-competitive activity, so training of board members to recognize market-sensitive areas is important. Finally, with regard to indemnification, the Attorney General's opinion did recommend that the legislature clarify that treble damages in antitrust awards are not punitive damages. This is important because the state in general is liable for injuries caused by an act within the scope of employment, but is not liable for punitive damages. And so that's why it's very important for board members to have the assurance that treble damages will not be considered punitive damages. This is an ongoing discussion. The Department of Consumer Affairs will be coming out with a memo shortly, and I expect they will be adding this topic to board member training, which is why it's so crucial as soon as possible that you attend when asked. Additionally, I expect there will be further discussions with the legislature about statutory fixes. Many individuals and organizations are weighing in, including the Center for Public Interest Law, and Ms. Dobbs and I will continue to bring this issue to the board's attention as appropriate.
Thank you, Ms. Webb. Any questions? Carrie, can you just put it in non-legal language what that active supervision is? That's the one I was a little concerned and I want public to hear.
Well, it is something that it can't just be on paper that a board's decision is being reviewed, but there must be an entity or individual that can review actions of the board before they are taken, particularly with regard to regulations that are market sensitive, and that person or entity has the ability to modify it or disapprove it, and that the board cannot turn around and veto that disapproval or modification. There's been some ideas floated, including that this could rest with the Department of Consumer Affairs, where there's already some authority to review some regulations, but currently the board can override a decision to disapprove those regulations. That would have to change. Another suggestion floated by the Center for Public Interest Law is to have this oversight authority rest with the Office of Administrative Law, which already reviews our rulemaking packages for 6 key items. This would be a 7th item added, whether it's anti-competitive, and to authorize them to make modifications or disapprovals that the board could not override if it is anti-competitive and not authorized by state action. The board's actions have to be in furtherance of state policy.
Okay, so I thought the administrative law judge had that authority, but this is an additional item, we are adding it to that, that's what I understand.
The administrative law judge deals with our enforcement cases. The Office of Administrative Law reviews our rulemaking packages, but does not look to determine whether they are anti-competitive.
Yeah, do whatever it takes to get us off on the FTC list. We don't want to be there. Ms. Dobbs, you have any comments? Any questions from the members? Okay, public comment, audience? Any comments on the phone?
We have no phone comments.
Thank you. Thank you, Ms. Webb. Next is item number 18, update on the breeze system by Mr. Eckelhart and Ms. Slow.
And Mr. Eichelkraut is not going to be here today. He just recently had a baby, and so we told him he should stay home and take care of his wife and the baby. So Ms. Lowe's on her own.
Right, good afternoon. I'm Natalie Lowe. I'm one of the licensing program managers for the board. I've been asked to present to you today and discuss the Breeze project from the board's perspective. I have personally been involved with the project since day one and acting as the board's licensing and cash sharing expert, as well as assisting with enforcement and general issues with the system. I've also co-chaired the licensing user group for DCA. So with that experience, I have seen quite a bit. I feel I have enough experience to speak on behalf of the board. So as I go through this, if you have any questions related to the board's process, I'd be happy to answer those. For questions in general for Breeze, Jason will be coming up afterwards to discuss it, so you may want to hold those questions. After having used Breeze in production for 2 full years, I can say that as an expert of the system, as well as the staff of the board who uses the system on a daily basis, that Breeze does work and meets our basic business needs. However, having said that, I completely feel that the system is not as efficient as what we want it to be, nor does it have all of the functionality that we need. The system gets us from start to finish the majority of the time, but there are many workarounds that must be done in order to complete our business processes. Some examples include when a new license is issued or one is renewed, a pocket card is generated and sent to a vendor for printing. Since transitioning to Breeze, this once automated process of extracting appropriate data and sending to our print vendor for processing now requires board staff to manually extract the data, review the records, and remove duplicate or erroneous information. We then send it to our print vendor for processing. For this, a request for change has been pending with the department since we went live to return the process back to an automated one that will meet our business needs. Another example of a workaround is when an allied health registrant reapplies for licensure after having let their registration go into a canceled status. For physicians and surgeons, a transaction was created in Breeze that made the process automated. We could update it in the system, approve the new license, and then the previous license record would be updated with the new information. For Allied Health, there's not a transaction available, which means that staff have to review and track the applications on paper and then manually manipulate the license record that's been stored in Breeze. We've also submitted a change request to DCA for this as well. This has been a work in progress to get the system to meet our expectations and our needs. In order to make any changes to the system, whether minor text changes to an online application or a larger programming change to the system, we must document what we want, how we want it to work, provide examples, and then submit a written request for change in writing to DCA with all of the available information. DCA then determines if the request for change is something within their scope that can be completed by DCA staff, or if the request is a programming or configuration change that must be completed by the vendor. All requests for change are reviewed to determine if the request is possible, who is responsible for making the changes, and how much time it will take to complete. These requests for change are the most time-consuming part of this entire project. In order for any changes to be put into production, it must go in with a release. Prior to Release 2, which is currently in the testing phase, releases were being done every 6 weeks. With each release that comes up, the board, we go through our list of change requests that are pending, and we prioritize our top 10. We then notify DCA of our top 10 change requests, which becomes our wish list for that release. DCA and the vendor meet and discuss and review our items, and they calculate each item into how many hours the request will take to complete. Because the time and resources available per release are limited and then divided between all of the boards and bureaus using Breeze, if our top priorities require significant change to the system and are time-consuming, it may take all of our allocated time for that release, which then can result in the board only seeing a handful of our change requests going in for that release. Now, if our prioritized requests are minor changes that can be easily fixed or take a relatively small amount of time, we can see more of our change requests going into a release. So at some, we could see all 10 of our top 10 going in. Other times, we may see 1, 2, or 3. And this is one of the reasons why the process to make any changes to the system is so time-consuming. We have to wait for each release, and then when when a release comes up, we are limited to what we can get in there. To put this in perspective, the board currently has 172 pending requests for change at DCA. That number fluctuates too. And in addition to those, there are 196 requests for change that will impact multiple boards. Some of those will impact the medical board also. And if we are only getting a handful of those put into production every 6 weeks or so, it could take years for our requests to be implemented. This number will also continue to increase as our business needs are always changing. For example, when a new law goes into effect, requiring additional information be provided by an applicant or a licensee, or when a fee is increased or decreased, a request for change has to be submitted to DCA. And depending on why we are making the request for a change, it may now become our top priority, pushing those other items down on the list. Because the changes that go into production are all based on the priority of the board at that moment and what can be included in a release, some of the requests that are pending at this time are ones that will have a major impact to the board, but have not yet made it into a release. An example would be the continuing medical education audit for physicians and surgeons. We've had a request in for this functionality to be put into the system for several months now. However, we've not been provided an estimate of when that will go into a release from the department. Also, we've requested functionality be implemented into the system to allow licensees to pay additional voluntary fees, but the scope of this request is too big to go into a single release. We continue to work on DCA with this issue at this time. However, because the programming and functionality will not be available, we'll be moving forward with updating our website with the information on how we can become compliant with this new law. Another issue that we've requested a change for is the load time of some of the physician profiles on our website. There are certain physician profiles that can take up to 2 minutes for the results to appear. That is one that has been submitted and is still pending at this time. I am concerned that these numbers will continue to increase as we are always having changes to our business processes and requirements, as well as now we are to the point where we would like to go back to those initial applications and transactions that went into production when we went live and enhance those to be more efficient. After having used the system for 2 years, we now have the knowledge and expertise of the available functionality and programming options that we could make the system actually meet our needs. This would be beneficial for staff as well as our applicants and licensees that utilize the online licensing system. Unfortunately, we cannot place a change request that enhances a current transaction that works in front of a change request that allows the board to be in compliance with the law or fixes an issue that has stopped our business process. If and when we are able to begin revising those existing transactions, it will decrease some of our numbers of pending change requests, as we'll be able to roll multiple change requests into one. Also, some of those older change requests, we now have new or better options that we can utilize, so we may be deleting some of those previous requests. Another major issue that the board faces is when it comes to reporting. When we transitioned to Breeze, we had very little reports available in the system. Luckily, medical board staff are able to program the majority of the board's licensing and enforcement reports that are needed. Unfortunately, though, they are now working to recreate all of the reports that we utilized prior to going to Breeze. This is a very time-consuming process, but there is progress being made. In addition to the current staff working to create the needed reports, our IT department will be hiring 2 limited-term positions that will primarily focus on report writing. This should allow for greater output of the necessary reports. However, it's important to keep in mind that although we can generate or create or program a certain amount of reports, 50 reports in 2 months, just random example, we still have to wait for a release in order to get those reports into production. So if it's not our top priority for the board at that time, or if we don't have space for that release, we may not be able to see those reports go in. If we create it today, it's not going to go in tomorrow is the thing. Also, it's very important that our reports that we are creating are only as good as the data that has been entered. This is a training and a staff issue. At this point, we're now trying to play catch-up since go live with the data that's been stored in Breeze. We finally have some production reports that we are able to utilize, and now we are able to go back in and clean up data and review records and make sure that it is accurate data. So with the report writing, not only are they programming the reports to meet the needs, but they're also having to create exception reports that we can review on a regular basis. Other issues that the board has faced include the lag time when processing applications or changing information in the system. There's sometimes a 5-second delay, a 10-second delay, a 20-second delay, which is a pretty big impact to board staff when you are having to click and wait 10 seconds for the screen to refresh, and then you click and you wait 10 seconds for the screen to refresh. It's a huge frustration with staff, and it's time-consuming. There's also other issues that there's lack of validation within certain fields in the system. There's lack of checks and balances. There's the lack of dependency requirements. All of these things that we had prior to going to Breeze. We have brought up several of these issues with DCA to be told that there's nothing that we can do. So it continues to be a frustration on some of these issues. Hopefully, when they come up, they can discuss some of them. Although there may be some frustrations when utilizing the system, I do feel that the system works. It needs modification and enhancements, which will take time, but eventually we will get the system to where it needs to be. I can say that as I consider myself an expert in Breeze. I use it regularly. It will take time, but it will get to a place that will be efficient for the board.
Ms. Lowe, can you wrap up, please?
Absolutely. I think the most important thing in order for us to proceed is that we will need additional releases, and we will need more time allocated per board in order to get through all of our change requests. That concludes.
Thank you. Thank you. I appreciate it. It looks like technology is supposed to help us, and I don't see why we can't have an app where consumer can look up, why we can't have an Oracle type of system where you can push a button and get reports. So it's just very, very frustrating. That's what my feeling is. But so the next one is actually, now let's move forward to DCA. Mr. Piccone. You're on the hot seat.
Apparently. Good afternoon, Dr. Gnanadev, board members, Ms. Kirkmeyer. My name is Jason Piccone, and I'm the Chief Information Officer for the Department of Consumer Affairs. I'm here today to provide an update on the current and near-term status of the enterprise-wide Breeze system. The current Breeze production statistics points to an answered demand for DCA online services. Online applications and online payments, payment acceptance is something that our licensed population want and use. The Breeze system has had over 806,000 unique account registrations. A very large number of licensees are using the Breeze system. Our data shows that when a program chooses to enable their renewals, as an example, in Breeze, between 50 and 70% of total renewals are completed online. And though the medical board is on the front end of that range, 50% still demonstrates a solid online cultural adoption. And actually, I was presented an updated statistic for the 14-15 fiscal year for physicians and surgeons, 63% of those renewals are completed online. The BREEZE system and the DCA community are adapting. In accordance, the medical board staff continues to work diligently to make sure that BREEZE can accommodate MBC work appropriately. As Ms. Lowe documented, staff accomplished this by working through the BREEZE IT governance process and submitting requests for change, work authorizations, and system investigation requests, or SIRS. Last time I was with you, I stated that DCA had secured an expanded, dedicated BREEZE maintenance team, that this team would be able to increase the frequency of application releases. Since that time, the maintenance team has implemented 5 to 7 week releases. Though we are currently in a code stabilization period, we will feature one more production release before the release to go live date scheduled in January. The accelerated maintenance team will resume after that January date. In addition to this maintenance team, the last 6 to 8 months have seen training and knowledge transfer between our contract integrator and DCA staff in the areas of configuration, technical architecture, and interfaces. Knowledge transfer will continue, and after the next group of DCA programs go live with BREEZE, this team will join the existing maintenance team to address system requests at an increased rate. Simply put, we will have more people working on more production requests. I mentioned that the MBC staff worked diligently through the IT governance process, so I'd like to thank Sean Eichelkraut, Nancy Smith, and Natalie Lowe, who, as she stated, is one of our BREEZE licensed user group chairpersons. I'm sure there are others, and I'd like to thank them also. I'd like to transition now to the area of reporting within the BREEZE system. BREEZE has a growing report offering, currently 34 standard reports and 126 custom reports. I'd also like to highlight the significant effort by MBC and DCA staff to produce enforcement reports that contain a wide range of valuable statistics. Many DCA programs are currently using these reports during their sunset proceedings. The DCA Reports Unit also provides bi-monthly data extracts that provide similarly valuable data for licensing. DCA is also available to work with MBC report staff on reporting needs. The department, in conjunction with our user community, acknowledges our continuing need to expand our reporting capabilities. We believe that an effective data strategy must address security, self-service, agility, and, as Ms. Lowe referenced, a reasonable development life cycle. What does this all mean? It means quickly putting MBC's data in the hands of MBC users and management and constituents in a structured and secure manner in order to facilitate management of day-to-day operations, make strategic management decisions, and effectively allocate resources to achieve program goals. To this end, the department is implementing a business intelligence platform, officially called Cognos, but departmentally referred to as the Quality Business Intelligence Reporting Tool. With this tool, we will be able to navigate agilely throughout our data profile. The DCA Office of Information Services has scheduled a preliminary demonstration of this system in early December. In more immediate news, and I'm being redundant to Ms. Lowe, the department is working with MBC to supplement its current report staff for both acute reporting needs as well as to include MBC in the early stages of the business intelligence development for more midterm goals. Lastly, and perhaps most relevant to this board meeting, to this board moving forward, we want citizens to search for licensed doctors and to do so quickly and easily. DCA acknowledges the opportunities that we have in the area of the BREEZE online search functionality. We are focused on the online user experience and plan to address these opportunities post-release to go live, which again is scheduled for January. Thank you.
Thank you, Mr. Piccioni. Any questions?
Oh, yeah.
Ms. Yaslovsky, Dr. Levin. You go ahead first.
I want to thank both Ms. Lowe and you, sir, for your report, and I have a couple of questions. I mean, I know it's very difficult what you guys are going through, but it seems that you've been going through this forever, and I just would like to know if there's any kind of a finish date where we can assume that Breeze is going to be working and functioning and meeting the needs of all of the DCA departments.
A couple of official finish dates, so to speak. The Breeze project, in its project form, will end in the first or second quarter of next year after the Release 2 go live and then the resulting stabilization period.
So are you saying to me that in June of next year, Breeze will be functioning and capable of functioning to meet the needs of this board as well as your other boards?
What I'm saying is just drawing a distinction between the Breeze project that has now lived for the past 4 years and an ongoing Breeze production and maintenance, referred to as maintenance and operations, post that time.
So I don't understand. Is that a yes or no answer?
Both and.
I apologize. It's just that this board has been putting up with, it's going to work, it's going to function, it's going to be more effective, it's going to be more efficient. We're part of one of 40 boards, so therefore the 800,000 users of the 300 we need, it's a whole lot of technical talk that I'm not so technical with.
Okay.
I just want to know, is it going to start working? I hear that you're going to put an accelerated team in come January. You've heard what the problems are, not only with our board, but I'm sure with other boards, as far as getting licensing done and enforcement done. And to hear that now in October, you're going to put one in January, what's wrong with them starting November 15th? I mean, I'm frustrated.
Sure. The answer to that question, why not start them today and why not start them yesterday, which again goes back to the Breeze project, ending after the Release 2 go live. All of our project and department as well as program staff are allocated to the Release 2 go live, which adds 9 more board programs to the Breeze production scenario. So that's the answer to that one.
So my problem with this is that you're moving forward to increase the capacity without ensuring that what you have so far is working to the best ability of the program. So it's maybe just a management tool to get everyone on board, but it seems to me that if, as part of getting on board, there are opportunities for fixes so that the function, form follows function, is not being met, but everyone's going to have it, but nobody's going to be able to work it. It doesn't make a whole lot of sense to me that this is the way things should happen. So understand that I heard very carefully your report, I heard very carefully Ms. Lowe's report, but understand I've been sitting here for many years now, realizing how involved and how engaged staff has been, but to the end, I'm not hearing of any kind of a end date that this is going to be working to meet the needs. It's semantics we're getting into. And the project versus the term project versus the ability for the project to work, to me means the same thing. So if Breeze isn't working and we're going to have to produce paper reports in order to get the information so that when we need to have the information to work so that we're not falling behind in our licensing and enforcement requirements, something's got to give and somebody's got to step up to the plate and say, we're sick and tired of this and we're not going to take it anymore. So I apologize, but I'm getting sick and tired of this.
I understand. Would you like me to try?
I just would like you to get people working and to make things happen so that when we have reports back, that in fact we're hearing that everyone is working to capacity. There's nothing more that can be done now. By the 3 months or 6 months or 9 months, everybody is going to be able to be functioning, and the corrections and the additions and the tools that are necessary to make it work, not just turn on the button and it goes live, but that it works and functions, that all of the departments can use, that needs to be addressed. So maybe you can come back to us at the next meeting and explain to me, if I'm the only one that needs to know, when is this going to function in such a way that it's going to meet the needs of this department? Okay?
Would you like me to
try?
Okay. Working through the 170 or so requests that Ms. Lowe spoke about is going to take time as we add resources to this
Could you define time? I apologize. I don't.
I apologize. I can't define a 6-month or a 9-month or a year-long process.
Okay.
Yeah, I had a question about ad hoc reports. I mean, one of the I think aspirations we all have is that when an issue comes up that we've never looked at before, we have the ability to go back and look and trend information or extract information to meet a one-time but potentially ongoing query. Is that something that eventually will happen? I mean,
Absolutely. I can give a better time frame into that end. That ad hoc reporting and an extended reporting functionality, let me back up. Breeze in itself has a more canned and more structured, developed, here's a report, this is what it looks like, and I'm going to put it out there for users to use, and I'm going to press the button, as you say, and have it print out. Past that, in a more ad hoc, in a more business intelligence area, is a separate product. And so, as I reported, the Cognos product is exactly what you're asking about. You mentioned earlier predictive analytics. Predictive analytics, so we go from just our basic reporting needs to an advanced reporting scenario, which I will say is coming with the Cognos product. Predictive analytics is a step beyond that. An excellent observation on your part, bringing that into statistics here for the board, and I would love to get into that area. I'm here now looking at the basic reporting needs in the advanced, which will take the ad hoc.
So Cognos doesn't get us to predictive analytics?
Cognos does have predictive analytics, yes.
But it's working now?
No, but the
product
question
itself,
is whether the platform
the platform does have predictive analytics, yes.
When will that work?
Thank you. Dr. Bollard.
Yeah, thank you very much. I wanted to ask a couple of questions because I think one thing that I was hearing, and maybe somebody on the board already has the answer to this, but we have a lot of aging, in my world, we call them tickets, you call them something else, but in other words, the requests. So if we have 160 or 200 requests and more keep on coming in, it's like aging. It starts to, maybe it was relevant at one point, maybe it's not relevant anymore. Do we have our requests from the medical board delineated, and I heard that we reprioritize them, but some of them may be even old. And see, you don't know what's old to us, and that would be something that, of course, you would all know. And how is that managed?
Yeah, it's interesting, and Ms. Lowe can probably provide more information, but it is true that as some of them have come up, when we reanalyze them, we do find that there's no longer a need for them. And I know that through the time, we've dropped a bunch off because now once we get to it, we don't need that, or we've had a different change to it. So that's something that's always an ongoing process. A lot of them are really, out of those, are bottom level. They don't need a lot of change. It's just, a nice to have kind of thing. And so those are at the bottom. And once we hit those, something may have changed to where we no longer need that. That's pretty much it, right?
Yeah, that sums it up.
As
we
we
have
analyze
worked
it.
with DCA, and we'll meet with them, and they'll go through the list and say, can we get rid of this? Can we get rid of this? Can we get rid of this? And a lot of them we can. They're so old, and we've reviewed them. We've made other fixes that have replaced that, sir. One of the other things is there are some that are pending, as I mentioned, for transactions that we want to go back and fix. We don't want to remove those from the list until we have a replacement for it to meet our needs, but there are some that will just be crossed off when we submit a new one.
And I wanted to talk one thing. I heard for the Cognos tool, it is not a long ways off in the future. Jason, do you know when we're going to be? It's distant future for us, right? For Cognos.
As I said, we're doing a preliminary demonstration early December.
Right.
We have to wait a little bit for the release to go live, but you mentioned a June date. I definitely see.
mentioned the June date. I was just reiterating. You said.
Oh, I said June? I'm sorry.
You said 3 months, 6 months. I turned that into June.
Okay, yes. Using June as an example, by summer, the Cognos tool will be performing in ad hoc. And just to clarify, I wanted to make sure that I set expectations appropriately. The Cognos platform does offer and accommodate predictive analytics. It's in a roadmap. It's in a couple-year roadmap for us, making sure that we hit the reporting needs. But your ad hoc comment, self-service is where we are going as much as possible, because the undesirable development life cycle, if we put that in the hands of your users, the constituents and your managers, it takes out talking to DCA, OIS, it takes out talking to anybody. You have it there for you to work with.
I just had a follow-up question to you, and you actually just touched on what I was going to ask, and that is the organization of your team, because there's I think you mentioned it. In other words, reports and reporting can be looked at, if it be ad hoc or even just reports that each department needs. Are you all one unit? Does everything flow through you, not you personally, but through your unit, in the sense that some organizations, obviously, because the demands for data become so high, it sounds like what you're saying is you're transitioning, hoping to get to this Cognos so that each unit, say the medical board, is going to be saying, here's what we need to run in terms of our reports, and you're thinking that Cognos is going to be robust enough to be able to be utilized by the end user to produce these ad hoc reports, or reports to do our business. Is that what you're suggesting?
That's absolutely. We, both for business sake and for our sake, we would like to be as much out of the reports business as possible, and that's just good business. We like to set up the back-end infrastructure both in a secure and structured manner, and make sure that a robust permission profile is overlaid across our entire enterprise, and then it's up to you. You have all of the data that you can manipulate, that you can put in whatever format that you require, both export-wise as well as PDFs to present to board members during these proceedings, but to use it at your discretion, and more importantly, at your time of need.
Let me apologize in advance for what I'm going to say here, but I value my time very highly, and I've sat through this for 15, 20 minutes now, and I hear someone here complaining about what they can't do, and I hear you answering no questions in any cognitive way and cogent way. I mean, it'll come someday, and I hear how you both love each other and you work so well together. I think that's great, but you know, and this is for Kim too. Kim, I really wish when we give reports like this that they say something. It doesn't do me or the board or anybody any good just to hear what we can't do, hear why we can't do it. I really just want to hear what we're going to get and when we're going to get it. That's just me. I mean, if everybody else thinks I'm wrong here, but I do apologize for this, but I'm just very frustrated. Every meeting, it's exactly the same report. We can't do this, and we don't know when it's going to happen. If that's all you have to say it in 2 sentences, so I don't sit here and waste my time. And I apologize. I know you're doing your best you can, and you've got a bad product. We all agree to that. We've all agreed not to discuss it, but I'm going to say it's a bad product. You were stuck with a bad product. So you're doing your best. Thank you. If that's all there is, I just don't want to hear the excuses, really. It's just waste my time. I'm sorry.
Thank you, Dr. Bishop. Thank you, Mr. Piccioni. I just want to make a comment at 30,000-foot level. I mean, in technology, I'm one of those technology freaks. I have TechWatch, I have everything tech you can think of. Anything in private sector which is not consumer-friendly dies. Dies, period. In the government, it just goes on and on and on inefficiently. That's what frustrates us. So we want you to really make it consumer-friendly. That's all it is. Make it friendly so that medical board or any boards are consumers. I mean, if Google, Apple, Oracle, all these guys can do that, why can't we? So that's all I want. I don't want an answer. I just want you guys to have a focus that way. And I know, I think you know pretty well as well as I do on this one, Apple had a culture. Basically, there was somebody called DRI for every project, designated responsible individual, period. that person's responsibility was to get it done in time. If not, that person was gone. So that's the way it functions in private sector. So if we can do it, I think we are so excited when we thought we had a new system coming in. Now it's just agitating everyone. Just a comment. With that, we have any comments from Julie? Genevieve, please.
Good afternoon, Geneviève Clavol. I have restrained myself quite a bit today, but I can no longer. I am so tired to hear about computer technology not working. And I totally agree with you two doctors we have said, I have been involved in information technology before Al Gore, invented it, when he was still Bitnik. So excuses you accept every time are absurd. I mean, that Breeze, the Cure system are all piece of junks. And we are paying. The taxpayers are paying for it, and we are getting nothing out of it. The Cure system, I have fought for it from the beginning. Oklahoma have a system, within 5 minutes, you know who bought a drug. Within 5 minutes. It a cure when you are lucky, 2 weeks. Is unacceptable. And it's time you stop for it. And it's every time the same thing. We are in California. You have JPL, Caltech. I mean, get those people to help you. Many will be glad to do it for nothing because they care. Back in 1981, I got them to do all the work for nothing. I got IBM to connect 150,000 universities for nothing. What you are having now is antiquated. It does not work. Make it happen. And with me, you don't have to look at the clock. I never speak over 3 minutes. And actually, it was a little bit of uncivility this morning, which I did not appreciate. And I think we are all the same time here, and we should obey to the rule. And thank you for enforcing them.
Thank you. Julie?
Thank you, Dr. Ganadev. Julie D'Angelo, Falmouth from the Center for Public Interest Law. I understood Ms. Lowe to say that when Breeze is causing noncompliance with the law, that would tend to vault the ticket up to a higher priority. And there is an area that I've pointed out before where Breeze is causing a violation of the law. Business and Professions Code Section 2027 requires this board to disclose detailed information about multiple medical malpractice settlements entered into by a physician within a certain period of time. For 2 years, none of that information has been disclosed on Breeze. Pre-Breeze, it was all disclosed on your prior website lookup, but it's not being disclosed right now. And I hope that's still at the top of the list. It's very frustrating to kill yourself to get a bill passed and then have a computer system come along and thwart the will of the legislature. Thank you very much.
So just so you know, it is our top priority in the work authorizations that we have.
Thank you. Any other comment from the audience? Any comment from the telephone?
We have no phone comments.
Thank you. Now we'll go to agenda item 19. Mr. Warden. Discussion and consideration of UniB Medical School application for recognition.
Board staff and Dr. Nuovo have completed their initial review of the UniB Medical School. Unfortunately, Dr. Nuovo is not available to come today. However, his report is included in there along with mine. I'll give you, we also have Lorraine Amell, who's the Dean of International Affairs, who's here today to address any questions you may have regarding the school. I'm going to give you just a few brief outline of what the school is. It's a nonprofit private institution in the Dominican Republic that's fully accredited by the Dominican Republic Ministry of Higher Education. It was founded in 1982 and it offers 15 undergraduate programs and 30 graduate programs. The Medical School of Medicine is a 5-year, 4-month program, and the first year and 4 months is basically pre-med. If students have a bachelor's degree that meets those pre-med requirements, they move on to the basic medical school. The medical school itself has a traditional regular track, which is taught in Spanish, and an international track that's taught in English. However, all third-year clinical rotations are done in the Dominican Republic, and the students must be proficient in English to proceed. Spanish to proceed. So they have done, most of the clinical rotations for most of the students are done in the Dominican Republic, although they are allowed to do some of the rotations in the United States if they would like to at the approved locations, and some other countries in Europe and Latin America. From that point on, Dr. Nuovo and I agree that the school is ready for a site visit to determine if it fully meets all the requirements. They've done a good job of providing us with that information. However, in order to proceed with being able to finalize our evaluation, it will require a site visit, and I'm going to request some very specific items. I'm not sure if Ms. Webb, I should ask for each of those items as a separate motion or just one motion.
When I read this, it seems to me to be a package, a nice package, and unless the members have an objection, I would list them out and get approval as a group.
So do you want a motion for items number 1 through 4?
Yeah, before you do, Ms. Jaslowski, I want to see if anybody has any questions to Mr. Warden. Dr. Lewis.
Yes, I have just a few questions that maybe you can or can't answer. They meet the requirements for the number of hours of medical school and the number of weeks of clinical, correct?
Yes, they do. Actually, they're a little bit beyond what our minimum requirements
Because we recommend, was it 72?
72 weeks of clinical rotations, 40 weeks of core rotations with 32 weeks of, and the other 32 weeks is elective rotations. And there's a total requirement of 4,000 minimum hours with 80% attendance. And the school meets all of those requirements based on the information they have submitted to us, but we need to visit the school to make sure that they have the facilities to teach all the students that they have, and they are willing to do that for us.
So this is to look at the clinics, the volume in the clinics?
Correct.
The curriculum, again, in person, face-to-face?
Right. So we're going to be looking, the proposal is to look at the medical school itself and the main teaching hospitals that they use for their clinical rotations, which is basically, they're all basically located in close proximity of the medical school. And that's what we're, once we finalize, if you approve the site visit, staff will, working with Dr. Nuovo, will finalize the exact locations that we want to see which we will visit all the core rotations for sure, and possibly some of the elective core rotations on top of the medical school, which also, when we do a site visit, it includes interviewing all the deans, teaching professors, medical school students, the faculty who teach the clinical rotation. It's a very detailed process.
Okay, so I'll make a motion to approve.
Hold on. Any other questions before we go? We do have a school staff member here, I think Dean, right? You have any questions? It's the time to.
She's back there.
Parliamentary procedure doesn't really matter.
I'm sorry?
I can make a motion.
Okay, so can you, go ahead. I do want to state, that's why I want to make sure that motion states. Can I have a motion to authorize a site visit to conduct a site inspection of UNIB and the clinical teaching hospitals in the Dominican Republic, to approve the composition of the site team to include at least one board member, one executive staff member, legal counsel, and a medical consultant, to delegate to staff the determination of the hospital training site or sites to be evaluated, and to approve staff to move forward with an out-of-country travel request to authorize travel to the medical school and teaching hospital sites in the Dominican Republic. That's still a motion. Thank you, Ron.
Move, whatever you said.
Okay.
Second.
So we have a motion and second. Any discussion? Being none, any comments from audience? Any comments from the telephone?
We have none at this time.
Thank you. Ms. Toof, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Aye.
And Dr. Gonadev.
Aye. Thank you, Mr. Warden. Moving to agenda item 20, update, discussion, and possible action of recommendations from Midwifery Council meeting. Ms. Parwan.
Thank you. It's good to be here again. Lovely San Diego. So the MAC has been working on updating the licensed midwife annual report data collection tool so that our statistics will more accurately reflect outcomes in California. We hope to have our recommendations to the board in early 2016. We're also looking forward to the crafting of regulations pursuant to SB 408, the bill that authorized midwife assistance. This will allow expanded access for consumers to quality midwifery care. And finally, regulations remain stalled pursuant to AB 1308, but we anticipate movement in 2016. SB 407, which was passed this year, allows for licensed midwives to provide Medi-Cal services through the Comprehensive Perinatal Services Program, but only after the regulations for AB 1308 are enacted. So hopefully that will spur the interested parties forward to getting this done. I need approval for the following agenda items for the Midwifery Advisory Council meeting in December. A task force update on the licensed midwife annual report data collection tool and interested parties meeting that was held October 13th, and discussion, update, and approval of changes to that data collection tool. Update on continuing regulatory efforts required by Assembly Bill AB 1308. I'm hoping Ms. Webb will be able to update us on that. An update on any legislation related to midwifery that was passed this year from Ms. Simoes. An update on the process of the challenge mechanism being reapproved for the National Midwifery Institute.
So moved.
So do we have a second?
Second.
Okay, any discussion? Any comments from the audience? Any comments on the telephone?
We have none.
Okay, thank you. Ms. Toof?
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis? Ms. Pines? Aye. Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Dr. Yip?
Aye.
And Dr. Gonadev.
Aye. Thank you.
Thank you.
We're moving on to item 21. We're all getting hungry, so we need to move. Update from the Enforcement Committee, Dr. Yip.
Hungry and cold also here, so my voice was quiver because I'm sitting right here. So anyway, the Enforcement Committee met yesterday, and we had a great presentation from Ms. Webb regarding the utilization review highlights, include the process of utilization review in workers' compensation and managed care system. The board's historical position that utilization review is considered the practice of medicine. Ms. Webb also provided the manner by which complaints regarding utilization review are handled by the medical board and the constraint faced by the board staff when processing this complaint. Specifically, expert reviewers do not have to be licensed in California, and the name of the expert reviewer is required to be kept confidential. Ms. Webb provides suggestions to the committee to improve the board's oversight. Therefore, the committee requests the full board to approve supporting legislative changes for independent medical review doctors to be licensed in California, to have similar board certification and/or training as the treating physician, and to identify themselves in the report. So we need your approval.
Thank you. So, Dr. Ip, you made it's committee motion, right? So you don't need a second?
The motion.
Second, you make a
Okay,
motion?
so any further discussion at the board?
Just be specific about what we're voting on.
Dr. Yip, can you repeat that, please?
Sure. The committee requests the full board to approve supporting legislative changes for independent medical review doctors to be licensed in California to have similar board certification and/or training as a treating physician and to identify themselves in their reports.
Dr. Levine, does that clarify? Okay, so any other comments at the board? Any comments from public? Any comments on the phone?
No phone comments.
Thank you. Ms. Toof, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Hopkins?
Yes.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis? Ms. Pines? Aye. Ms. Shipsky?
Aye.
Aye. Aye. Dr. Yip?
Aye.
That'll do it.
Okay.
You missed me? You missed me. Aye. So actually, now I'm getting so used to it. Audience, public, everything. So we'll go to item 22.
A more report. She,
Oh, you still have?
Yes.
Haven't finished. I just
few
said
more,
I'm
few more
getting used to
minutes.
it. Go
Ms.
ahead,
Robbins
Dr.
also updated committee on the demographic studies. She has been in contact with the California Research Bureau and advised the study is ongoing, and hopefully we will provide current update on the study in the January board meeting. Ms. Delp also provided the committee with update on the enforcement program. She stated field vacancy remain, and once filled, staff will be able to improve upon the complaint processing timeframes. Ms. Delp then mentioned an issue raised by the Office of Attorney General regarding the use of the same investigator that works as a complaint both criminally and administratively. The Attorney General's office is asking for the Division of Investigation to develop a parallel policy for this type of investigations. In November, the board staff will reach out to the Division of Investigation in the AG office to address the concerns of conducting parallel investigations with the goal of reaching an agreement that works best for all agencies. The committee also updated on the vertical enforcement legislative report. The board staff will meet with the DCA and the AG's office to discuss the highlights and challenges of the vertical enforcement process. The report is due to the legislature in March 2016. The intent is to have 2 board members work with the staff once the report is drafted to review and provide feedback regarding content. A draft report is expected to be completed and provided to the board at the January board meeting. However, if not completed by that time, a special meeting may need to review the report held in February. Ms. Depp also advised the committee the development of a cloud to share case information electronically via a secure system has been developed and will be utilized by the board staff, the DCA Division of Investigation, and the Attorney General's office. A meeting scheduled November 3rd, 2015 to discuss implementation of this electronic process. Ms. Kirkmeyer and Ms. Depp also advised the committee of the meeting with the Office of Administrative Hearings. The purpose of the meeting was to introduce Ms. Delp as the board's new chief of enforcement and also discuss the new uniform standards for substance abusing licensees. During the meeting, they discussed training to provide to the administrative law judges on topics including but not limited to prescribing practice expectations, impairment, and how it impacts the practice of medicine, and medical record keeping standard expectations. Ms. Delp update the committee regarding the expert review training. The goal is to conduct training in March 2016 in Southern California. In addition to training, the program developed a recruitment plan to expand the number of experts within specific specialties. Also, the expert reviewer database called the MedX is expected to be overhauled to enhance the system and make it user-friendly for board staff, investigator, medical consultants to search for qualified experts to assist with the complaint investigations. Finally, Ms. Depp provided an update regarding the board's involvement into the issue of over-prescribing psychotropic medication to children in foster care. It's been challenging for the board staff to find an expert to give an opinion on the data that was provided by the Department of Health Care Services and Social Services. However, staff will meet with a potential consultant next week on November 9th, and is hopeful that physician will be interested in working with the board to give an opinion regarding those pending issues. On October 12th, the board staff met with executives from this department to give them an update regarding the board analysis of the data, and explain the data may not be sufficient to make a determination regarding the overprescribing issue. The board and agency developed a notification process whereby individuals in the healthcare delivery system for foster care children can contact the board if they believe a physician is inappropriately prescribing medication to children in foster care. That concludes the report from the committee meeting yesterday.
Thank you, Dr. Yip. Any comments or questions to Dr. Yip from the board members? Any comments from the audience? Any comments on the phone?
No phone comments.
Thank you. That concludes the item 21. Now we'll go to item 22. Update on the interim suspension order study by Ms. Kirschmeyer, Mr. Gomez, and Ms. Castro.
Well, I'll try to be brief. I want to direct your attention to pages BRD 22-1 and 22-2. As you may know, at a prior meeting, the board directed staff to work with the Attorney General's Office, the Health Quality Investigative Unit, and us work together on finding ways and strategies to expedite cases that were, we thought would be interim suspension orders. And so I'm just going to briefly go through the items, just to let you know we did have a couple meetings. We looked at cases, specific cases that were interim suspension order cases. We looked at all of the information surrounding them, including the decisions that came out from OAH and kind of our process that we had gone through to get there and how long it took for us to get there. And some of the cases as we went forward, I mean, just in all honesty, anytime you do a review of your cases, I think you run into, oh my goodness, what were we doing in this instance? Why did it take so long to get from here to here? And really trying to analyze what the factors were that weighed into that. And so I think overall, I think one of the biggest issues is the identification of this case, and I think it covers several of our items, the identification of the case and then the monitoring of that case as it goes through the process, both by the medical board, by the Attorney General's Office, and by HQIU. I think that really was one of the main focuses that we identified. You know, sometimes it looked like maybe things just may have slipped through the cracks in the monitoring, and I know part of our issue has been and I don't want to pull off the, Band-Aid, but part of the issue has been that we just haven't had the monitoring reports that we've needed to ensure cases are moving through the process. So Gloria and I get reports from the AG's office, and now I think we're at a point where we can now rerun the reports that we have. So we're going to be able to monitor our cases back and forth and then bring in HQIU. I think it's been a little bit easier for us to get AG case reports, so we're going to be working on that. So just quickly to run through the list, the first thing that we identified is there needs to be some training for our experts, and the biggest thing is that those individuals need to understand when they're doing a opinion on one of these individuals, it can't be wishy-washy. They really have to come back and say this individual can or cannot practice, or they can practice with specific restrictions. And so actually the AG's office and HQIU worked on revising the letter with their actually expertise from their med consultants, and so that was one of the big things. So I'm going to talk about the items that have been implemented too. So this number one has actually already been implemented in the fact that we have revised the letter, and then the other thing that we're doing is we will be working on this through the expert training program to improve our experts in that area. The second thing we identified is if there is a need for restrictions, no matter what those restrictions are, we need to seek an ISO. We'll let OAH deny it, but we need to move forward. So if the expert comes back and says the individual cannot practice unless they are in group therapy, then we'll go forward, because the only way to ensure that that's happening is to get it in an order from the administrative law judge. So we're going to be pushing forward with that. Board monitoring, I've already talked about that, so I'm not going to go over that again. Close monitoring of Business and Professions Code 2220.1 6.A, it specifically states that within 30 days of an 805 or an 80501 report going out to the field, that we have to identify whether that is a case for an ISO. And I think we've been doing that. I just don't think we've paid close monitoring for that. So Ms. Delp is actually going to be in charge of that, and we've actually already improved that process, which kind of goes to the next one, in that right now we're going to be emailing out these items to both HQIU as soon as we get them and the AG's office, so they can co-assign those cases and move forward on those cases. So we're in the process. We used to do it snail mail. There was really no reason for that, so we're going to be emailing those out and getting them going, and Ms. Delp's following up on all of those cases that go out within that 30-day time frame. The next item is that there will be AG report reconciliation. So everybody knows kind of where, not just AG, but board and HQIU, and this goes back to the reports and following up on those, so I'm not going to go too much more into that. Number 7 is that we actually request the Office of Administrative Hearing to expedite ISO decisions. And then in addition, we had asked that they specifically, when they're granting an ex parte basis, to issue the ISO immediately. Ms. Delp and I did go over these 2 items with the Office of Administrative Hearings, and they did state that when they could, they would issue those immediately, and they thought in most cases they do that, but they also did reserve the right on some of those to obtain additional information if it was necessary. And we agreed with that. The next one is that we recommend training to Office of Administrative Hearings, and as Dr. Yip and Ms. Delp stated in the committee, we're working on that already. Update the investigation report synopsis. So this was one where it may not have clearly said in the investigator's report, the report of investigation that went to the Attorney General's office, that I'm referring this for an ISO and an accusation, and so they went, that's already been completed. When Ms. Sweet was still with HQIU, she sent out a note requiring that to be part of the report of investigation. The next item is that both the lead prosecutor and the supervising investigator, during the entire course of the case review, they're going to be looking at whether that case needs to be an ISO, because as one thing we found out was that the case actually could start out looking like it was nothing, and then in the middle of that case it turns into a need for an ISO, and so the 2 teams are going to be working together throughout the process to identify that. In addition, we're going to put, the Health Quality Investigative Unit actually sends a document to the AG's office and to us talking about what they did in that month. It's called a monthly activity report. And we've always put on, those referred for accusation, those who are referred for criminal, those closed, but we've never put on those referred for an ISO and really brought it to everybody's attention. So that's going to be added, and that's something that's already done as well. In addition, any disagreement on a case, we want to make sure that it immediately goes into the dispute resolution process as outlined in the new vertical enforcement manual, and so that was another thing we identified, because sometimes just going back and forth in the process, it might not have gone into the formal process, and it takes a long time sometimes to get resolution, so we want it to be very formal. The next item is something that's come up outside, actually, of even the ISO review, but this has really brought it to light, and that is a process that the Attorney General's office has requested, where if a case is going both criminal and administratively, that there is a parallel process, and that's looking at HQIU to be looking at a process and a policy. Actually, it's a parallel policy. And so we're actually going to be meeting with the Attorney General's office, with HQIU, and working on some resolution to this issue, because it's really actually a larger issue, and then I can even write down here on this, in this report. But the thought is the investigative, sometimes they get investigative information, and I'll ask Mr. Gomez and Ms. Castro to just back up a little bit on this. So sometimes they get information one way through the criminal case that they may not be able to use in the administrative, and they can't taint the case. So that's the background on that. And then the last item is that in BREEZE, we want to actually have a way to identify these ISO cases. So it's a code that we can put in there, and then we can run a report and quickly identify those cases and check on the status of them. So those are the things that we identified, and I leave it to my colleagues to add on anything they want to.
I wanted to add.
Thank you. Ms. Castro, thanks for coming. Please go
Yes.
ahead.
I wanted to go ahead and add to item number 13. As Kim pointed out, any good policy meeting usually ends up giving more work to the people involved where they identify problems or issues that we hadn't thought of quite before. And obviously, the overriding policy of a board such as this is to coordinate, complement, triage, and maximize its resources while preserving, for example, the constitutional rights of doctors. And so this body is much like the FDA, DHS, EPA, IRS, SEC. You have both criminal and civil components to your mandate. So the medical board is no different and should pursue all of its remedies with vigor. Parallel proceedings involve criminal and civil administrative actions against the same individual for conduct arising under the same set of facts and generally consist of simultaneous, sequential, or overlapping criminal, civil, and administrative proceedings. Now, the Attorney General's office has always had a parallel proceedings policy in place, and so our staff in HQE has always been bound to not participate in criminal proceedings against doctors. And prior to the turnover to HQIU, the medical board's focus had been very small and concrete with the Operation Safe Medicine, Operation RX, and we maintain that wall. And it's a parallel track, and the track should not cross. And so it's become incumbent upon HQIU, DCA, to bind its investigators, who are your agents in your medical board, investigations against doctors. Now, Business and Professions Code Section 2006 essentially says that any investigation by the board shall be deemed to refer to a joint investigation conducted by employees of the Department of Justice and HQIU under the vertical enforcement and prosecution model, as specified in Section 12529.6 of the Government Code. However, as I've mentioned already, our staff in HQE does not direct criminal investigations. We follow our policy not to do that. 2 different attorneys need to be assigned and 2 different investigators need to be assigned. And quite frankly, the vertical enforcement model never contemplated AGO direction of criminal cases. So HQE is not monitoring or directing criminal cases being developed by HQIU against doctors. But we are requesting a second civil investigator be assigned where probable cause exists for criminal issues to arise. And the context of the ISO gave rise to that, because more than likely, if something has criminal components, it is an ISO as well for public protection. So in order to keep that mandate very clear, I think that the medical board does need to properly administrate its investigations and precautions must be taken, and that is why a parallel proceedings policy must be instituted forthwith by the DCA, and we're happy to help with our expertise at the Attorney General's office. And this is to avoid claims that the medical board and DCA investigators that are acting on your behalf have violated a doctor's constitutional rights by the use of civil discovery. And obviously, civil discovery should always be undertaken in good faith, as well as criminal discovery, such as search warrants, should not be used to advance civil cases. So we're looking forward to getting that important work done for the benefit of the doctor's constitutional rights and obviously for the medical board's mandate, so you could maximize your resources.
Can I ask a clarifying question?
Yeah, go ahead, Dr. Levy.
Is that complicated if it's federal criminal versus state criminal?
Parallel proceedings policies apply even with federal. So for example, US DOJ that prosecutes, let's say, a pain management doctor who is overprescribing. And we don't have that problem in those particular cases, Dr. Levine, because there's 2 investigators and 2 lawyers assigned. So we have US DOJ, US attorneys assigned, an FBI agent, and meanwhile, we could be operating in the civil context. And so for years and years, we've had complementary evidence sharing, and obviously the public policy, especially in healthcare, wants to advance the maximization of evidence. But at the same time, maintaining those separate tracks. So that way, Fifth Amendment, constitutional rights, discovery is not utilized in a way that is not proper, and that actually could expose the medical board to criticism that it's not administering justice in a very fair way. We don't need to do that. I mean, if a case is serious, there's more than enough for everybody.
But I guess my question was, does that imply 3 lanes of parallel?
No.
Okay.
No, yeah. Well, Mike. I think sometimes there are federal laws that are not, cannot be pursued by state, but sometimes the state has more in their pocket that can help federal. It's usually the other way around. The feds ask the state to pursue claims. And I'll leave that to Mr. Gomez too.
Right.
So just a point of clarification. So what I'm hearing is that there's more of a coordinated effort by multi-government entities within the same purview of the same doctor.
Right. So there's 4 different types of contexts where we see criminal issues. Number 1, criminal convictions that have already occurred, that the medical board becomes aware of, and that we look at. That doesn't present any parallel proceedings issue because pretty much the criminal investigation has already resulted in a criminal filing. A second type of criminal matter that arises is when we find out that somebody else is investigating, such as DEA investigating a pain management doctor who's operating outside the bounds of common decency. We may find out about that and open up a civil case, but again, because there's 2 investigators and 2 lawyers assigned, it does not present any issue. A third component is also when we find out that the district attorney or anybody else is about to file, and we have to decide whether or not we're going to pursue our ISO and possibly jeopardize a criminal case, and that becomes an interesting conversation between prosecutors. The fourth example is the one that applies here, and that is when it's an HKOU-led investigation based on probable cause, and these decisions have been made unilaterally by HKIU, and they're operating on your behalf as your agents to pursue those criminal cases. It's in those cases that my staff, our staff at the Attorney General's office, is bound by our parallel proceedings policy, and also I would submit the vertical enforcement model to stay in our lane, which is the civil investigation component of it, but also to make sure that these things are not getting commingled and that no criticism can come to the board by the misuse or perceived misuse of civil discovery for criminal components or criminal discovery for civil.
Thank you. Question.
Yes.
If there is a event or a collection of events that triggers both criminal or civil proceedings against a physician as well as board investigation, does the board action sometimes get ahead of the civil or criminal proceedings? And can the board action of these same events be introduced as evidence in civil and criminal proceedings?
Yes, yes, and actually in the ISO context, that's where it presents itself, more than likely. Because like I said, criminal cases that are very serious also are ISOs. We don't want that physician practicing. But the difference is clear. The medical board disciplines licenses, right? And so you prohibit a person from using a license to treat patients. Whereas the criminal process, that goes against the person, and you're trying to deprive their liberty. So that's why we're talking about similar things, but 2 different lanes. One is license, the other one is the doctor and his or her liberty.
But again, what I am hearing is that board actions on the same event can be introduced as evidence in the civil and criminal proceedings.
Right.
Thank you.
And that's what a parallel proceedings policy would help to elucidate and to make clear for investigators, so that way separate files can be maintained and there won't be commingling of that evidence. But eventually, once it's ready to go, and it happens all the time with the district attorney, let's say, we won't be able to use their evidence until they make their filing. Then we subpoena and request from the judge. Let's say there was a grand jury, we try to get those documents if possible. If we can't, we can't. But we make a concerted effort to not reinvent the wheel, grab the evidence that's already available. But that evidence is not available to us unless everybody's ready to go. And of course, in a confidential criminal investigation, we may know that something's going on, but we may not have access to the evidence because the criminal defendant is not aware of the criminal investigation. And by us having it and us going first, civil-wise, it kind of blows it up. So.
Thank you, Ms. Castro. Mr. Gomez, thanks for coming. And first of all, we want to make sure that treating our enforcement staff, I want to emphasize this, our enforcement staff, well, they're parked in your shop. So with that, please go ahead.
You may ask any one of them how I treat them. I treat them pretty well. Just to clarify, item number 13, this has been a discovery actually for us, and similar to your prior agenda item that related to the probationary status issue of the notification. This also has a broader application to the entire department, because although we have HQIE within the Division of Investigation, we also have the Investigation Enforcement Unit, which also does investigations outside of the Health Quality Enforcement section of the Attorney General's Office in the Division of Licensing for the Attorney General's Office. So we have the VE policy, this bifurcation proposal that has not been proposed on the other side. So we need to make sure that whatever we're doing for all of our licensees, that we're doing it with equity, with justice, with consumer protection in mind, but that this is an item that needs to be really discussed in much further depth, because it's not quite that simple. There's a lot of other impacts here in terms of the respective houses, not only of the Division of Investigation and all the other bureaus and programs of the department that deal with administrative and criminal matters as well.
Yeah, we expect you to work with our staff on this.
We will.
So.
And I want to thank the board actually for directing this study. It has really highlighted, I think, our focus on not only the expedition of ISOs, but where the gaps and where the results that we were able to accomplish in this, that we really needed to highlight, the ISO matter, as Dr. Ganadev and David Serrano, your president, have really emphasized that this is a matter that needs to be really focused on in terms of doing it more, not just more efficiently, but in a better way that we can better protect the consumers with the tools we currently have.
Thank you, Mr. Gomez. Any questions? I do have one public comment. Yvonne Cheng.
Good afternoon, Yvonne Chen with the California Medical Association. We believe that further discussion needs to be had, and we'd like to get more information on number 13. We have some concerns. This pertains to Gray versus Superior Court from 2005, which held that PC 23 does not authorize a licensing agency to recommend license restrictions as part of bail conditions, nor does it authorize a criminal trial court to suspend a professional license upon the recommendation of a state licensing agency. So as this process is developed, we want to make sure that Gray is strictly followed to the extent that the medical board or HQIU is proposing to get license restrictions imposed as a condition of bail. So that's something that we just wanted to highlight for the board. Thank you.
Ms. Castro, any comment?
We did not discuss that in the context of the ISO, because the bail restrictions actually prohibit the person from using the license, and that is actually what we request and get all the time from judges. So no one except for you has jurisdiction to bind any license or its use. You're the only one. So when we want license restrictions, we come to you. We want restrictions on a person to use the license to continue to hurt people. The criminal courts deal with that. So.
And just one follow-up to this, too, is I don't want anyone to think that by us working really hard on these ISOs that we are going to, in any means, step away from the PC-23 issue, because PC-23s are a lot quicker than an ISO in a lot of instances. We can get action quickly, we can post it on the board, and there's no time restrictions then for usually filing any further information, like how we have to file an accusation in 30 days. So I don't want anyone in here to think that we're not going to continue to use that very important tool for us.
Thank you, Kim. Any other comment from the audience? Any comments on the phone?
We have no phone comments.
Thank you. Thank you all. Ms. Castro, I think you are still there, right? Okay. So the item number 23 is Investigation and Vertical Enforcement Program. Mr. Gomez and Ms. Castro.
Good afternoon, members of the Medical Board. Michael Gomez, Deputy Director for the Division of Investigation and Enforcement Programs. I want to make two announcements before we make our presentation today. At our last meeting, my colleague, who is not sitting to my right, Laura Sweet, Deputy Chief Laura Sweet, retired effective the 30th of last month. So with that, I'm here to introduce our new Deputy Chief of the Health Quality Investigations Unit, Kathleen Nichols. And it is my pleasure to tell you a little bit about her because she'll be working closely with Kim, and I think Kim knows of the expertise and the familiarity with the medical board's work, that Kathleen Nichols has over 20 years of experience in law enforcement, investigating and supervising cases at the medical board. And since July 2014 with the Division of Investigation, Dr. Ganadev. She has a bachelor's degree in criminal justice from Northern Arizona University and is currently attending Command College through the Commission on Peace Officer Standards and Training. And just to let the members know, to be enrolled in the Command College at Post, it's extremely competitive. It's usually captains and above. You have to be selected by not only your agency head, but selected by the commission to attend this course. So you have a very special person working with you. Kathy started her career with the fraud unit of the medical board and was promoted through the ranks most recently as a Southern Area Commander for the last 8 years, supervising the Tustin, Rancho Cucamonga, San Bernardino, and San Diego field office. Kathleen has provided numerous post and outside presentations to law enforcement and hospitals throughout the state. She enjoys a variety of cases and is committed to the mission of consumer protection. She looks forward to being part of the exciting changes we have before us and the renewed focus we have of the Health Quality Investigations Unit. So with that, congratulate her, I guess, in recognizing her promotion to the next Deputy Chief.
Kathleen. Welcome. Even though in my mind you left better part of the state and went to Sacramento.
Thank you. It is an honor and a privilege to be the Deputy Chief for the Health Quality Investigation Unit at the Division of Investigation. As we move forward, our vision is to have a renewed focus on consumer protection. We will identify and prioritize ISO cases and those that present the biggest threat to the public. Our focus will also be on avoiding time gaps in investigations by ensuring that the lower priority cases are rotated to keep them moving. We will continue to provide high-quality, thorough investigations. We are also focusing on investigator retention, which is crucial to the success of our program. Some upcoming events for HQIU are that replacement cell phones are being programmed and distributed to HQIU offices in November. We also have 2 investigators from each office that will be attending the upcoming CNOA training also in November. We have a medical consultant statewide meeting and training scheduled for January 2016, and we are in the process of finalizing a lesson plan with the Attorney General's Office HQE staff for joint training on 805 investigations. Our target date for the joint training is February of 2016. Whoops. There we go. In addition, field training officer pay differential has been approved by the director and has been forwarded to CalHR for final processing. A HQIU retention pay proposal drafted by former Deputy Chief Laura Sweet was submitted to the director and will be included in the collective bargaining process set for spring of 2016. Numerous hiring panels are taking place throughout the state to fill investigator vacancies, and this is a top priority. I'm very excited to share with you a new program rolling out to all HQIU offices. It is an electronic case binder system. It was developed by Detective Dan Pierce of the San Diego Sheriff's Department. It has been adopted by the San Diego Sheriff's Homicide Unit, San Diego Police Department, and the San Diego District Attorney's Office. It was recommended to HQIU by San Diego HQIU investigator Steve Brewer, who came to us from the San Diego Sheriff's Department. It was given to HQIU free of charge. I want to give you a visual here so I can share a typical case with you so we can see the wonderful possibilities of our new program. Most cases involve large binders full of paper attachments and dividers. This particular case is 14 binders. We have many cases much larger than this. In fact, we've had a case with 90 binders before. This case is 133 pounds, 2.5 cases of paper, and with all the shipping costs, both to the expert there and back, the cost is approximately $250. With the new electronic case binder program, there are no binders, no paper, and the cost of the CD and shipping cost to the expert and back is approximately $7. Besides the obvious cost savings, this program is a much more efficient way to share information. What you see on the slide is a sample of what the table of contents looks like when you put the CD in your computer. It has all the case identifying information on the left, and on the right is the investigation report. All attachments and audio files of the physician interview are all listed under the table of contents. These items are scanned and hyperlinked in the table of contents. You can select any attachment, click on the link, and it will pull the attachment right up. We are currently providing training to each of our field offices on the use of this program, and we'll be implementing it immediately with new cases as they come in. We will be communicating with our experts as we roll out this new program. You do not need any additional software to run the program, only to load the documents. I should add, it needs to be on a Windows operating system. We also envision this to be used not only in expert packages, but also for transmittals to the Attorney General's office. They are supportive of our efforts, and we hope it will be a great asset to both sides. It might also be utilized for case documents that we normally copy and mail hard copies to the medical board. We need to embrace technology and innovation in our work, and I think this is an excellent way to start. Moving on to our vacancies, we currently have 25 investigator vacancies out of 76 positions, which is a 33% vacancy rate. 16 investigator candidates have been identified and are in background. I am pleased to report that since these slides were submitted, we have identified another 5 candidates to verify eligibility and start the background process. There are 6 more anticipated vacancies, which are investigators that are currently in background to leave to go to other agencies. The state SROA hiring rules have resulted in an unprecedented exit of many investigators who received job reinstatement offers from the agencies that previously laid them off. And numerous hiring panels are taking place to fill our positions. The retention pay proposal for HQIU investigators is crucial to retaining investigators. We currently have 25 vacancies. Retention pay is worth the investment in investigators who are highly specialized. The cost of continually rehiring investigators is almost equal to the cost of the retention pay proposal. In other words, you're paying this money out anyway, as we continually have to rehire staff. It is not realistic to pay 18.5% lower, have a more complex caseload, and have double the volume of work of other investigative agencies. We need your support in this endeavor to retain our investigators, whose knowledge base is crucial to our mission of consumer protection. Investigators who have stayed need our support. With the recent departures of several investigators to the Department of Corrections, caseloads have doubled. An ideal workable caseload is 15 to 18 complex cases per investigator. In many areas of the state, investigators are now assigned 30-plus complex cases. We will focus on identifying and working priority cases and eliminating time gaps in non-priority cases by rotating them in a systematic fashion. We are offering overtime as available within our budget to keep up with the workload. A retired annuitant investigator position has been recommended for an investigator due to retire at the end of the year so they can stay on and keep their caseload. Investigators recently received a day of emotional survival training presented by Dr. Gil Martin, which took place in September for the South and October for the North. This training was extremely beneficial for all staff. I am committed to supporting our investigators and would like to publicly thank them for all their hard work and dedication. I wanted to briefly explain the data parameters for the case aging statistics. We cannot obtain this data from Breeze reports at this time, so staff are manually compiling data. There was no retrievable data for February of 2015 and also for July and August of 2014. All the other months have been provided so you can see the month-to-month comparison. For cases over a year old, there was a slight reduction from August to September. There was a similar slight reduction for cases over 550 days old. And the next 2 slides compare this year with 2014 and are also included for your review. But in the essence of time, that will conclude my report, and I'd be happy to answer any questions.
Thank you. Barbara.
I want to thank you. Welcome aboard. But it's me, and as Mr. Gomez will explain to you, have a role in this. I'm a bit disturbed by all this information, I have to tell you, and I have some questions. Vacancy rate of 25 out of 76, maybe 33%, but it's a big percentage. And my concern is with this kind of a vacancy rate, how are the cases being handled? How are they being assigned? How are they being prioritized? How does the medical board understand the work plan of what you're doing? I mean, this is a scary time.
Yes, with short staffing, the cases are being prioritized, and our first effort is to identify those cases that need an interim suspension order, those cases that involve impairment, that need to be acted on immediately. That is still happening. The other non-priority cases, the vision moving forward with a lower amount of staff, is to rotate them in a systematic fashion so we don't have huge gaps.
I'm hearing that you've got complex cases of 30-plus cases per investigator.
That's correct.
So how is that impacting on the workload being completed? How is it, what are the time frames? And I understand also, I heard you say that you're not able to get the Breeze reports. So how is it that we're going to stay ahead of the curve instead of behind the curve?
Well, the part in organizing the cases is, for example, in a 5-day work week, 3 to 4 days of that week should be focused on working the priority cases, those that would present the most harm to the public. That other day a week, the investigator should take 2 or 3 of the non-priority cases that aren't ISOs, do a few activities on those, and each week rotate those cases so that in a month or 2 they would have worked on every single case. What we're trying to avoid is a system where we'd have cases just sitting there, and that's just not going to be acceptable. So this is the plan we're moving forward with until we can replenish our staff. But as I said, we could be sitting here a year from now having the same conversation if we don't address the bottom line of why this is happening.
Dr. Lewis.
Your last statement is exactly what I'm going to say. And it's like, don't shoot the messenger. You're coming in here and welcome, but we've had the advantage of seeing this for years. And I can almost put up the same slide next year or the year prior, and it's the same slide, and it's the same issue with staffing. I don't think I've heard anything new in staffing, and I understand Mr. Gomez and I have gone back and forth of this, but how can you do the volume? It's a rhetorical question if you don't have the staff. What I'd like to see in the future, for me, is really where you come today and where you will be tomorrow and the next day. I need to see the numbers. The complex cases have gone down. This board needs to see that we can be reassured that our complex cases are actually really moving forward, because that's our mission, to get those moving. So that's the information that I'd like to see the next time.
Dr. Lewis, we can provide you with that information, but I want to kind of restate something that you said, is that even prior to July 1st of last year, the whole retention issue existed prior to them coming over here. We're still challenged with that same phenomena. However, to the extent we have control over those components that relate to case management, that we relate to the redirection of staff to the priority cases, that is what we're doing. Those things that are in control, we're pretty good at doing. I think there's no doubt, and I'm not even looking at my deputy chief, but every investigator that I have met, they are committed, they work hard, even when we give them overtime, but they're working as hard as they can. There is no, quote, this is a Marine Corps term, there's no sick, lame, and lazy thing going on with HQIU. So we have taken all the corners of the management's protocol to really prioritize, identify case types, identify, as the deputy chief mentioned, the rotation, spending certain times focusing on the priority cases and then also dealing with the non-priority cases so they don't languish in case age forever. You don't want the wave or the bottleneck of cases coming out.
So before you can, while you have Mr. Gomez, because Mr. Gomez didn't have a chance to respond to me, but while you're doing that, with our investigators, when they moved over to your department, we were told that one of the biggest problems was that salary and the retention of the salary. So how is it that our since the transition has taken place now, can you share with us how the investigators are doing? I mean, are they getting their pay raises, or are they leaving for other jobs because the pay raise is higher? What's the problem with retention here?
They're leaving because the pay raises are definitely higher. This is not a 5% pay raise when they leave. It's at least $1,000 a month to CDCR. Number one. Number two is that they're getting the same, I hate to say it, they're getting the same retirement benefits for less cognitive work. You have to have the investigative and writing skills in this particular job, which you don't have to, and I don't mean to belittle any other classification of state worker, but, being a parole agent, I don't think you have to have this kind of talent, writing talent, cognitive talent, interview talent that needs to be done in complex cases that we have. So there is a mismatch of I think, complex recognition of work.
So within your report up there, you suggested that as part of the bargaining, next year's bargaining program was an increase in salary?
Yes, so there was a retention pay proposal where an analysis was done showing the amount of money that is spent, hiring people,
Right,
putting them through the academy, all of that. Your difference in the pay retention, I think it was an additional $360,000 per year is all it would cost to give staff that 18.5% pay reduction. And I completely appreciate the point that you keep hearing this over and over again. I've been here for 20 years. I've lived it. So all we're asking is that we're imploring the board to support us in this retention issue, whatever is needed to let the department know that this has to take place. This is what we need in order to successfully protect consumers.
Let me make a comment on that. If you look at any company, including the government, retention and vacancy are almost always system problems. So there is a real problem in system. It's either salary, it's the benefits, or it is the work environment. So we expect you to really give us a proposal. I know you're working through the system. It's a bureaucracy. There are unions. I understand all that.
It is.
But give this board a proposal to support you, exactly what you want, and we will seriously look at supporting you.
Right, and members, I think, going back to what Dr. Ganadev said, is that it is systemic. It is the civil service system, and we have a lot of competing collective bargaining units, and for whatever reason, ours wasn't there. And I don't know what that history is, but I'd have to work with Kim a little bit more to determine what the approach would be. But I work for the director, and this is something I've already brought to his attention. He's been supportive of it. We have the package ready to go, but it has to wait till collective bargaining.
Mr. Chair.
Kim, go.
I just wanted to state that this really is nothing within the board's control, though. This is something that does have to go through bargaining, through the normal process when they come to the table. Unless I'm incorrect,
No, you're right, Kim.
I don't believe
You're
that
right.
there's anything that we can do within the board's control.
Can I ask a quick question? I think someone mentioned this. We've been on the board for many years. Your predecessors came here and made the same case to us over and over again, and nobody would listen. The legislature jumped and decided it would change where the investigators would be supervised. My concern is I heard from your predecessor, and I'd like to ask the same question. Is it true that you can't recruit from outside the DCA component or other state investigative? In other words, you can only hire people who have been state investigators in some capacity, because that seemed to be a problem in the past. They were not allowed to go outside and take from police departments and other places.
No, that's actually not true. We can hire from other law enforcement entities. We also have a continuous online exam where college graduates that have a degree in criminal justice can take the online test and also be eligible. We have been recruiting heavily with retirees that are retiring from law enforcement agencies that are not in PERS. So those are some of the candidates we're selecting. Part of the issue we're facing is that everybody knows that the job at HQIU is more complex, higher workload. So if the pay isn't there, it's not going to be competitive.
What's the comparison in salary?
18.5%.
Between your particular area and the other investigative areas?
Yes,
Okay, well,
that's a huge difference.
and that has been systemic, that has been ongoing. We've heard this for years, that the difficulty is that there's a large pay gap. And, the question becomes, why would people take this job if they could go elsewhere? Also, you were taking in people, training them, and then they would go elsewhere once they received the training for a higher pay.
Right.
Is that still occurring?
Mhm. Yeah.
It is systemic.
Thank you.
It is systemic, and to the extent that, I think I brought it up last time.
Looks like
but-
nobody's
I'm sorry.
hungry. Go ahead, Dr. Bishop.
I'm sorry.
I just, I hear this again, and I think I said this last time. What can we do to help? First of all, we saw the power of the people today with the Consumer Union Health, or whatever they did. But look, what they energized that today. Can we enlist their support? Should I and all the other board members go to our local representatives as both taxpayers and board members and say, look, this has to be done. You wanted to make the changes. You made the changes, and it didn't help. But here's what we really need to do. So I'm trying to be very constructive here. You folks seem to be trying to be very constructive. What else can we do to support this? Because I agree with you. This is crazy. What can we do to support this? Aside what I've said, I'm going to call my person next week and say, look, I spoke to you earlier in the year, and I need your help. This is critical. This is going to require legislative fix as far as I can see. Yeah, and I think we need to motivate the legislature somehow. Right.
So, just so you know, it isn't a legislative fix. It truly is a bargaining unit issue. And, we have legislative intent that says our investigators should be within, what is it, Ms. Nichols?
Right.
10% or 5% of what the special agents at the Department of Justice is paid. However, even though that is in legislative intent, we have never been able to move that forward. It really is that bargaining unit.
And Dr. Bishop, just to clarify, that the CalHR is the exclusive bargaining department for all employees of the state. I work for the administration. I can't do that. That's up to them. I can only recommend to my director and give him the reasons why that should happen, but they're the exclusive bargaining agent for all the employees.
I'm empathizing. I wonder why the LA Times and all these papers that chastise us and criticized us and were all over us a couple of years ago aren't taking this to heart and saying, look, this is an issue in our state. This is something that's critical. Maybe I'll call up the San Diego Union Tribune and say, do you realize this is happening? This whatever it takes that's legal, I'm willing to do.
Well, and I understand it's a collective bargaining issue, but in that sense, the collective bargaining is the employees, and then there's the department. Obviously, if the department came forward and offered this 18.5% pay proposal, you're not going to get any opposition. So the question is, what can we do or this board do to let CalHR and the department know that this is something that we expect?
But just to clarify, members, we have that retention proposal already at the director's office. It's already done, it's already there.
Thank you, Mr. Gomez. I just want to remind everyone that a couple board members have flights coming up pretty soon, so unless it's very important to ask, don't need to have repeated things. But Ms. Castro, please.
I'll do my VE report very briefly. It's been a pleasure so far to work with Ms. Delp, Chief of Enforcement, so that is very good moving forward. We are now on our third Deputy Chief of HQIU with Ms. Nichols, and we're very excited to be working with her. And she assures me she's not retiring anytime soon, so she's in for the long haul. So it's nice to get a little more stability upstairs moving forward, because we are almost approaching a second year since the July 1st, 2014 transfer of your investigators to HQIU. So we're looking forward to working with her and with the new supervising two area commanders that will be instituted statewide. So next year will be great, especially as we move forward on doing our vertical enforcement report with Ms. Kirkmeyer and Mr. Gomez. I'll move on to my HQE report. I was asked to give you a report on the Lewis versus Medical Board case. As a reminder, the Lewis versus Medical Board case involves a Court of Appeal decision that ruled that the board's access to cures during the course of a disciplinary investigation did not constitute a serious invasion of the patient's right to informational privacy, and further that there were two compelling state interests weighing in favor of the medical board's use of cures. Number one, controlling the diversion and abuse of controlled substances, and two, exercising its regulatory power to protect the public against incompetent, impaired, or negligent physicians. The Second Court of Appeal also held that to impose a good cause requirement before accessing cures data would necessarily involve litigating the privacy issue in advance, and that this delay would defeat the legislative purpose of cures, which is really to allow doctors to instantly look up a new patient's controlled substance history to determine whether the patient legitimately needs pain medication or is quote-unquote doctor shopping. So Dr. Lewis appealed this decision to the California Supreme Court, and it adopted his petition. We are not done fully briefing it because very recently, on October 27 and 28, new amici brief were filed. The ACLU filed an amicus brief on behalf of Dr. Lewis on October 27, as well as the Electronic Frontier Foundation. And on October 28, the CMA, AMA, California Psychiatric Association, California Dental Association, American Dental Association filed a brief in support of petitioner. And so the respondent, the medical board, which is the real party in interest in this case, will file a brief in reply to the recently filed amici brief, and we think that the oral argument in this case is anticipated in the spring of 2016. And so we represent you along with our Solicitor General in the case in front of the Supreme Court. And again, we're going to be defending the decision below, and specifically the issues include whether the board violated any patient privacy rights or not. We believe not, obviously, in looking at cures. And so we'll move forward with that, and I look forward to updating you next time we see each other at the January meeting. And just a brief staffing update. Supervising Deputy Attorney General Thomas Lazar, the supervisor in the San Diego office, is retiring after 30 years of illustrious service to you as your attorney and as a supervisor of a very distinguished staff here in San Diego. We're very, very sorry to see him go. He is one of the architects of the vertical enforcement program, which came into being now 10 years ago, well, 11 years ago. And so we bid him farewell. He's left his house in good shape, and we'll backfill his position as soon as possible. So please join me in saying thank you to Mr. Lazar for all his fine work. All right, and that concludes my remarks. Thank you very much.
Thank you, Ms. Castro. Any questions to Ms. Castro from board? Any public comment on items 23 and 24 from the audience? Any comments on the phone?
Currently, there are no comments on the phone.
No comments.
Thank you. Thank you. We really appreciate you coming here. We're coming to the end. Items for January 2016 meeting in Sacramento area. Any board members have any items they want to add?
That's off. Yes, I have a couple. One is the first thing, can we look at the fictitious name permit issue? We have got to do a better job on disclosure about which physicians are behind the fictitious name permit, and also all the locations, making sure. I know I've sent something to Kimberly, and there's a difficulty. People get the permits, and there's not much. I know we're just talking about enforcement, but there's not enforcement checking that they're actually only at that location, and those are the doctors that hide behind the fictitious name. The other thing is the issue of franchising medicine. As a nurse practitioner, I'm getting inundated with offers to buy a franchise, as physicians are, for medical weight loss and for medical spas, and that would constitute corporate practice of medicine as well as fee splitting. And there's a number of actually legal articles out there online about trying to warn doctors that this is corporate practice of medicine. But perhaps maybe we could have a discussion and we can put that somehow in the newsletter to let physicians know that this is not what it appears to be, and they could put themselves in jeopardy over it.
Just to let you know, at the prior meeting, the prior 2 meetings ago, we actually had a big presentation and also put it in our newsletter, but Ms. Webb is actually on a work group with the California Medical Association, and we're hoping to have something out soon on corporate practice, even more than that.
Okay, great, good.
Dr. Lewis.
And I had just one additional potential agenda item for the next year. Could we at some point hear from any of the deans of education of some of the medical schools regarding the changes in medical education? Medical education has really advanced in the last several years, and also especially dealing with more of the psychosocial issues that medical students face. It doesn't have to be in the next board meeting, but maybe in the future we can get an update from a local medical school. Thank you.
Any other?
Maybe just a corollary to what was just stated is the medical school's approach to physician shortage that we know we're going to have in California. Just to begin, perhaps not the next meeting, but I think we're going to have to talk about that. It's very, very important. It's just the physician shortage, healthcare shortage, we say physician shortage, and is there an approach that the medical schools have to that? What's their plan?
Okay. So any comment? Hello, Genevieve, go ahead, please.
I just want to let you know that for the last 4 years, most of the dean of medical school have been meeting under a project named Beyond Flexner, and are reviewing, totally reviewing the medical design, and they are meeting again next year in Florida. And actually, I've been the only member of the press who have followed them. I'd be glad to send you the...
Yeah, thank you. I do want to make, there are 2 new medical schools started in California in the last couple of years. And a third one, which we are starting, is going to probably will be there in 2017, and there might be another one Kaiser is looking at. So there are medical schools coming up. I think the biggest issue is the residency programs. We'll discuss that too. So, any comments on the telephone?
Currently, we have no comments over the phone.
No comment.
1 second. Just there is. You don't need a motion to adjourn, but I do want to take this personal privilege to thank you for putting up with this rookie on this tough board meeting, and I also want to, my staff wants to make sure that you return all your thumb drives before you leave. With that, we're adjourned.